not like to take this matter, my lord.
Any connection?
Yes, Lordship has appeared
19 matter.
before for this petitioner. Lordship has appeared earlier.
Okay. Please, before any other bench without me.
Lordship may kindly that may be fixed, my lord.
We are not
Answers is
fixing. If you are not touching, please be listed before the appropriate bench. Yes.
All right.
Yes, may I please, Lordship, I beg to mention item number 14, Lordship.
Yes.
So, Lordship, in this petition, Lordship, the respondent authorities file their affidavit in opposition just 12 June, Lordship. So you need to file the reply, Lordship.
17 matter.
17 matter, Lordship, the matter lead to the selection of the principal, Lordship. Now they are denied that the petitioner is not on a.
What is your name?
NH Lordship, Lordship.
The NH Lobster Learned Council prays for and is granted 2 weeks time
2 weeks.
to file rejoinder affidavit against the affidavit in opposition filed by the respondent and against the affidavit in opposition which has been said to be filed by the respondent recently. Yes.
Post please.
May I please, Your Lord? My lord, I beg to mention item number 15, my lord.
Yes.
Matter become infected.
D. Gogoi.
My lord.
D. Gogoi Learned Council for the petitioner. Secondary education, Tarangri.
Thank you, Your Lord.
And state council. State council.
Mr. Not there.
State council.
Secondary education only.
State is not there. Okay.
Item 15, my lord.
Okay.
Thank you, Your Lord.
May it be please, Your Lordship. Lordship, I beg to mention item number 35, 42, and 44. 2 weeks time may be allowed to file impeachment petition, Lordship.
These are connected matters.
No, Lordship.
In all the matters, you need to file for impeachment.
35, 42, and 44.
35 is 16 matters.
35 contain, Lordship.
Learned Council for the petitioner submits that there has been change in the incumbents holding incumbents who were party respondents. Learned Council accordingly prays for and is granted 4 weeks time to take steps for
Lordship,
implementing new incumbents.
Lordship, item number
This is 35.
35, 42, and 44.
Yes.
And item number 36 and 37, Lordship. We need more time, Lordship, for instruction. We could not contact our client.
36
36 and 37.
These are 16 matters, madam.
Lordship, we could not contact our client. Lordship.
Will not adjourn. We'll have the matters called upon. If you do not have contact, we'll dismiss this matter.
May I please, Your
16
Lordship,
matter.
beg to mention item number 43. This matter will be kindly adjourned for 2 weeks because my senior's wife has been hospitalized.
Okay. 43.
43.
Okay. This court has been informed that there is some medical emergency for the learned senior counsel appearing in this case. Taken the consent?
Yes, I have taken consent.
List after a week.
Next, Mr. Lordship, I'm on behalf of Harvey Gora. He is election court number 1. Kindly pass the call.
What is the matter, Mr.
My lord, this
Guru?
is regarding the seniority. This petitioner is the founder teacher of high school, and the respondent number 4 is the teacher of ME school. In 2007, this both school amalgamated. Initially, the petitioner was given the in charge headmaster. He make an objection, and entertaining objection, the petitioner was demoted. He was given in charge. Now, question is who is the senior man? That is the crux of the matter, because he is from ME school, and with his own request, he came to the ME school. Then ME school amalgamated with high school, and they.
But ME school, the headmaster will become the assistant headmaster.
But he is assistant teacher only, not a headmaster.
On the amalgamation,
Yes.
even if a headmaster of an ME school becomes the assistant headmaster of the amalgamated school,
Yes.
You were what? You were
Here,
you?
I am the now senior most teacher of the high school and amalgamated school also, as per their graduation list, my lord, which is given. And only
Who is for a private respondent? Yes, what do you say?
Lordship, his service was regularized, that was a venture on 1/1/2013. That seniority he is claiming. But law does not permit, so he has not
And
completed 10 years.
when does your seniority from
I am enjoying from my seniority. BTC has also given their additional affidavit from 1996.
96? But he says that on your own request you had come to this group.
Rule 24(3) of 2018 Act. Subsequently, I was transferred from Sautara to this school, MA school, in 2015. That is within the same district. And that seniority has been protected by law. 2018 Act.
2018 rule.
Rule. So BTC has also given this clarification was earlier sought in the earlier round of hearing on 23/3/2023. That
23?
yes, that has been now clarified and on last day, BTC has given their affidavit. 23/3/23
Yes,
of
yes.
hearing. Matter was hard as line.
Then let her come.
Yes.
We'll try to take up for hearing.
I am available.
Yes, next.
May I please, Lordship?
Yes, what-
My lord, I am always a social science teacher. The respondent number 9 was the headmistress of the school. But at the time of submitting particulars, misusing her power as headmistress, she has shown herself as the social science teacher. Actually, she is the headmaster. For instance, Lordship may kindly see page
The
4.
pleadings have been exchanged.
my lord, we have filed, they have not filed any reply. My lord, here, my lord, name of
No,
the
no, no.
petitioner.
Do you take this up for disposal or what?
My lord, lordship may send it to the appellate authority, my lord. Here, my lord, name of the petitioner has not been recommended by the district scrutiny committee.
For provincialization.
My lord,
That is not
Appeal on the 14th.
my lord.
because my lord, wrong particulars were submitted. That is why district scrutiny was kept in dark. So
Will you
otherwise-
agree to the proposal that if we send it to the send you to the appellate forum with liberty to make a fresh challenge if it goes against you?
it may be decided by High Court also. There is no bar.
Even then, my lord, petitioner has.
No, most of the
In
cases,
many cases, this High
most of
Court-
the cases we are sending to the appellate authority. But if you insist, we'll decide.
I
But
want
the decision will not be today. Pleadings are over. We'll fix it for disposal
My lord,
whenever you say.
Right.
Today it may not be possible. It will go immediately after the vacation. Tell us the date.
immediately after.
Yes. Tell us the date. Tell us, suggest the date. Heard. Heard free. M.U. Mahmood, learned counsel for the petitioner.
July 18, my lord, Tuesday, July 18.
Also heard. Sri P.K. Bora, learned standing counsel, elementary education department. Whereas, for number 9, your name? F Intals. F Intals, for respond number 9. Learned counsel for respond number 9. The issue is with regard to provincialization of the services of the petitioner
And respondent number 9.
vis-a-vis the respond number 9. Full stop. Pleadings have been exchanged and the matter can be taken up for disposal at the admission stage. Full stop. Para. As agreed to by the parties, Kumar list for admission hearing on 18th of July.
Paula.
Not 18th, 28th of July. 20th,
my lord.
Thursday.
Paula.
Obliged, my lord.
3 and 4 RDB. A prayer for adjournment has been made on behalf of the petitioner. Affidavit
We have filed our affidavit, madam.
has been
We have filed,
tagged or not?
we have filed it on, madam.
Affidavit has not been tagged. Why?
Filed on, madam, 8.
No affidavit has been received. 22/5. Para, this court, by the order dated 12/6/2023, had directed tagging of the affidavit in opposition filed by the department on 8/6.
We have filed on 8/6, madam.
8/6. Put up. However, it appears that the said affidavit is yet to be tagged with the case file. Put up, para. List after a week along with the affidavit.
It may be because he has not received salary notice from him. No.
You filed in which case?
With 2184/2023.
2184 it is there. 29332.
No, madam, in 2184 we have filed.
It will cover the other
Yes,
case
yes,
also.
madam.
But then, no.
Matter may kindly be taken up at 2 o'clock. Maybe taken up at 2 o'clock because matter rejects the lordship non-payment of salary also. And she is a cancer patient also. So at 2 o'clock, may I tell her? Oblige that.
2 o'clock.
Yes, madam.
Oblige.
Yes.
Lordship,
19 meter way motion.
Lordship, leading counsel, Mr. ARBI is on lag, so adjourn for the time. Lordship.
But why are you taking time of this matter? It is 2019. 3 occasions matter had come up. You had taken time. Are you interested in the matter or not?
Lordship, whatever I have been received the instructions, Lordship, this is a connector, another connected matter is going on before the revision bench. This is a matter regarding selections of madrasa TET qualified teacher. So Lordship, he will apprise you about the status of the case. Lordship may drawn the matter for timing.
Madam, in fact, read appeal is pending, madam.
No, we can issue notice at then.
In landed single bench, madam, dismiss the petition, madam, and they have preferred an appeal, madam.
Understood. We can issue notice.
Yes, that can be done, madam.
No point of a matter of
Pending in,
2019 without
yes,
notice.
Notice can be issued, madam.
We issue notice
Lordship.
and it say that we await the outcome of the.
Yes, madam.
Your name?
N.M. Azarbuya.
N.M. Mazarbuya.
N.M. Azarbuya.
N.M. Mazarbuya. Counsel for the petitioner appearing on instruction of the ARBL and counsel for the petitioner. Put up para. The petitioners who are 13 in numbers are aggrieved, have alleged discrimination by the state respondents who state respondents in their case who are madrasa TET qualified candidates in the category of HS3 senior section. The petitioners had also prayed for a consideration, prayed to consider the application, consider their application in the category of assistant teacher Hindi pursuant to an advertisement dated 11/3/2018. So far as the subsequent prayer is concerned, after about 5 years, is whether the relief can be a matter of consideration is a question which will require, which should arise. This court has further been informed by Sri N.J. Khatuniar, learned standing counsel. Elementary,
Here, secondary, my lord.
Secondary Education Department, that a similar writ petition was dismissed by the learned single judge, against which a writ appeal is presently pending. Be that as it may, comma, that notice be issued returnable by 4 weeks. 3. Attorney General Standing Council
And it
accepts notice on behalf of respondents 1, 2, 3, 4, and 5.
Yes, my lord.
All the respondents.
All right.
Let extra copies of the writ petition be served upon him by Monday. Full stop. List this case after after the disposal of WA.
I'll give it to you.
Highly obliged.
May I please, Your Honor? Lordship, I is for recruitment of party. Earlier, respondent number 1 and 2 name as per order name was deleted as per order dated 24/4/2019. In the meantime, Lordship, SCS Dhubojyoti Das holding the charge inspector of school Dhubri, and Sahadat Ali holding the post of principal of Hamidabad College.
Where are your notices?
Lordship, Annexure A. Annexure A, page 7 and 8.
These are to the present incumbents.
Yes.
Holding the post of principal and
Yes.
IS.
SCS.
Inspector of school.
Yes.
Why have you earlier the principal was not there?
No.
Why now?
We don't have any instruction, Lordship, in this regard.
No. Why are you trying to implement the principal who was not there earlier? Mr. Talia?
Some report may be necessary from him, you know.
No, was there any direction to him? Let us see the operative part of the court's order. Is it 29? District Scrutiny Committee.
It was to the district scrutiny committee,
Principal is not a part,
but for scrutiny committee, records have to be placed by him only.
but this is a contempt proceeding.
That is true, you know.
Let us imprint the inspector for the time being.
My lord.
He will call for the record.
My lord.
Third, DP Chalia, senior counsel, assisted by MS M. Roy. The present IA has been filed for implement of present instant by implement of the present incumbents holding the post of inspector of schools Dhubri and the principal of Hamidabad College in the district of Dhubri. This court has been the learned senior counsel has drawn the attention of this court to the representation dated 24/4/2023 issued by registered post petition AD to the incumbents who are sought to be impeached. Full stop. Para. However, comma, a perusal of the order dated 6/6/2017 passed in WPC 5587 of 2017, in respect of which the present application has been filed, reflects that the direction was given to the District Scrutiny Committee. Full stop. In that view of the matter, comma, this court is of the opinion that for the present, comma, the present, for the present, the inspector of school who is presently posted, the incumbent who is presently posted as the inspector of school may be impeached. Full stop. Accordingly, 382
Number three,
ACS in charge
as number three.
is impeached as respondent number,
Three, oh. It will be three.
I think 2.
No, two was not earlier deleted.
Yes. So it will be 2, I think.
Or
2
maybe
has already been deleted earlier. Will be respondent number 2. Full stop. I accordingly stands disposed of. Full stop. In the main contempt petition, you write, in view of the order passed to them, whereby impeachment of the present incumbent holding the post of inspector of school has been allowed, comma, registered to make necessary insertion of the state incumbent, namely so as of number 2. The learned counsel for the petitioner is accordingly required to take steps by registered post petition, which will be done by Monday. Therefore, issue notice to the newly impeached respondent number 2 and step. Yes.
But this is a election and appointment junior Christian Minor in EMB school in Nagaon district. But, respondent authority did not file any affidavit, my lord. That is either record or affidavit is required.
4 and 6 have filed, 9
Yes,
have
yes, all private respondent file, my. The thing is that here the nephew of headmistress has been got appointed. That's all of the
nephew has mistress cannot be a brilliant person.
no, it can be, my lord. Can be.
Is that a disqualification?
No, it can be.
That he is the nephew of this headmistress, he can never be appointed.
Can
He may be a rank
my lord.
holder.
So just
Is that his fault that he happens to be the nephew?
no, the relation is there with the headmistress, my lord. So
No, that
rec-
cannot be his fault. If
No,
you
no,
say that he is
yeah.
otherwise inferior, he doesn't
Cannot be
possess
his
the
fault.
eligibility, then the matter is different. Only because he is relation of somebody
No, cannot be his fault, but I was also selected out of 10, my lord. But selected has been published, my lord.
has not been published.
No, man. There's a record, my lord, either record or affidavit, my lord.
No point of adjourning this matter. 16 matter. Yes, Mr. Katani.
In fact, this is school selection committee, madam. Director has otherwise no role, madam. The entire selection process is conducted
By the SMDC.
Yes, madam.
Yes, who is for the school?
I think they have filed their affidavit, madam.
They have filed affidavit, but no select list, man.
Where is the school? Who's
Yes,
the,
sir, that is
who's for the school committee? As per number 9,
respond number 5 and 8.
5 and 8. They have filed affidavit on 14/2.
Yes, my lord.
Who is there? Names, Mrs. Sinha? 8.
5 and 8.
Raj Bor Bhuya. MH Raj Bor Bhuya. MSP Hatti Gayari.
No, madam. Item number 7, madam.
Item number 7.
Yes, madam.
Oh, P
P Sharma, S Soikia, P Soikia, my lord.
P से क्या?
5 and 8.
P से क्या? पवित्र से क्या?
Maybe, my lord. My lord, take it after some time. I will confirm.
Call him, call him. And what about the other counsel? D.K. Sharma, Dharmendra Kumar Sharma, 4 and 6. S. Bora, Gargi Kashyap.
My lord, take it after some time. I will inform them, my lord.
If they are not interested to defend, we'll allow this application. Call them.
Oblige.
Mr. Sinha, you also try to locate them.
Yes, sir.
Anybody?
Yes.
May I please, Your Lordship? In this case, Lordships,
As per the, my lord, as per the last order dated.
FU versus RB.
Lordship,
FU versus RB. Mr. Asbar Bhaiya,
My lord,
FU
Greetings,
versus
Comrade.
RB. Not understood. FU Borbia versus
MH Rajbur.
MH Asbar Bhaiya. Yes, so what is the
Lordships, here is
My lord,
the
as
case.
per the last order dated 17/5, learned the government advocate is supposed to file the record of the case, my lord. As to see what.
but the affidavit has been filed
They are,
by
they are
6, 5, 6,
affidavit-
and
Filed
7,
by
9,
the
8.
private respondent, myself, for
You're for 8.
8.
Bo-
And for
Who's
the
for 5,
managing-
6, and 7?
managing, okay, another advocate is there, my lord. He
5,
has
6,
also
who
filed
is
a
appearing
petition.
for 5, 6, and 7?
My learned friend is
So
next.
you are appearing for 5, 6, and 7.
5, 6, 7, all. Yes.
On Rehanabego, my lord.
No, you are also appearing for 5 and 6.
Yes, yes. Earlier case appeared all the 3 respondents.
And who is for 8?
8 for 8, myself have filed a petition. Private respondent.
Yes, no, we got that. Second file, only got connected.
5, 6, 7.
Doesn't read. It is a Organic. I don't know if petition or respondent. Madam, you are for 5 and 6. Where are you?
Sorry, Your Lordship, I'm looking.
8, 8. Who's for 8?
Myself, for private respondent.
You have a colleague called Khadija Begum.
Khadija Begum.
Yes.
I'm for insert. I
And
filed a.
earlier, initially I filed the writ petition Lordships on 2015. In that case, my
Who's for the
learned
department?
friend
Mr. Khatanier?
appeared headmaster, including
We
private
take this up,
respondent.
this is a old matter for disposal. Yes.
My learned friend also
Well,
appeared in
there
the
are-
private response also. Here is the case, Lordship.
Oh, 1 second. So why two petitions?
Initially, I filed a writ petition challenging the appointment of private respondent number 8,
1651.
1651.
Yes.
After on receipt of notice, my learned friend appeared private respondents as well as headmaster. Contended that my service has been terminated.
Your service.
My service. That's why second writ petition has been filed.
Challenging this termination of your
Yes,
service.
Lordship, because so the Lordship
Okay.
in 2428 may be covered in 2015 case. Lordship.
Okay, we have 2428 will cover the both the
24,
cases.
yes, earlier case will be covered.
1 second.
Earlier it.
1 second. 1 second. Let us take it for disposal. 1, 6, 7. 1651 for otherwise for against what?
Again, termination.
No, 1651.
No, Lordship. So challenging the provincialization of the service of respondent number 8. Khadija Begum.
Alright. And the other one?
Other one,
2428.
on receipt of notice, they have submitted affidavit in opposition against my case,
Against termination.
against stating that my service have been terminated long back in the year 1999. That's why second petition was filed.
Okay. What is the school in question?
Yes, Lordship. Here the school, the Tarinipur High School, it was established in the year 1959. And
Just a
that
minute.
school was recognized
Just a minute. It is in the Kachar district.
Kachar district
Tarinipur High School.
High School. It was established in 1959 and recognized on 1/1/1990.
Okay.
In need of second
It is a high school.
high school.
Okay.
In need of second law division assistant, I was appointed by the managing committee
When?
on 28/2/1996. That is page 25 is my appointment letter.
We are referring to 2428.
Lordship. Yes, 2428.
Page
Yes.
pagination will be of 2428.
Yes, my appointment letter is
Page
page 25.
25.
Lordship.
Yes. Your appointment as
Appointment as LD assistant
by the managing committee.
by the managing committee.
Yes.
And that was, I joined the service on 1/3/1996. Page 26 is my joining letter.
Yes. Learning report.
Lordship. My appointment was approved by the inspector of schools on 31/3/1997. That is page 27. As second LD.
Yes, of Kachar.
Kachar Lordship. Inspector of schools, CDC, Silchar, Kachar. Kachar district approved. Prior to my appointment, initially, one Jalaluddin was appointed as law division assistant. Lordship. He died on 26/12/2007.
2007.
2007. 26/12/2007.
He was also working as LDA.
He was working as LDS, past LDS.
He expired.
He expired.
Okay. Thereafter.
On his death, his wife, respondent number 8, has been appointed on 4/2/2008.
Wife of Jalaluddin.
Jalaluddin. He is only 8. At the time of appointment, she was more than 36 years. Condition is that age has to be 18 to 36 years. At that time, she was 41 years. And qualification also below loss required to be for appointment, higher secondary is required to be passed. Then, after coming into force of the 2011 Act for provincial service employees, also responded, headmaster forwarded the particulars before the respondent authority for provincial service. Your lordships will find page 28. Particulars forwarded by the headmaster. That is dated, date is very much important.
Page 28.
28.
Yes, please.
That is dated 3/10/2012. Lordship will get left side the top, and even bottom of lordship will find
3/10/12.
lordship. Page 30 also lordship will find page 30 bottom.
Yes.
310. Behind the back of me, headmaster forwarded the particulars of respondent number 8. Kudeza Begum. Lordship will get bottom last but 2 Kudeza Begum.
Your name is not there.
Lordship, my name separate sheet submitted except because only one has to be considered for provincialization.
What is your name?
My name is Saleha Begum.
Saleha Begum.
Saleha Begum. My name forwarded separate sheet accessible. Your Lordship will find Khudeza Begum age also mentioned 47 years. Junior resident, date of engagement is very much important. 4/2/2008. And also find Lordship, he is also HSLC pass.
HSLC pass.
HSLC. My name forwarded separate sheet, access employees, page 32. Page 42.
47 years.
Uh,
What is
The-
the age?
my
No, Khudeza?
of Khudeza 47 years, 5 months.
4/2/2008. HSLC. And your name?
My name Saleha Begum,
Where?
separate sheet, access employees, my name has been forwarded. Page 32. Start from 31 particulars. And page 32, Lordship will find my name.
Where is
Bottom Saleha Begum Lashkar, class 1 classical or 1 for language teacher. Saleha Begum Lashkar, junior assistant 2. At that point of time, I was appointed junior assistant 2.
This is excess employee.
Yeah, yes, so access employees. And Lordship date may be taken into note 3/10/2012, same date. Earlier one also 3/10/2012. This one also 3/10/2012. It was signed by the headmaster. Same date, both particulars have been provided.
What are you saying? Which date?
Date is important, Lordship, 3/10/2012. Both on same date.
The earlier was also 3/10.
3/10, Lordship.
Yes, 3/10/2012.
Yes. Then name of
You
the
are
employee,
also HSLC.
HS.
HSLC.
We are shown HSLC, but I am HS. One SS missing, but I
We
am
do not know,
HSLC.
but here it's called HSLC.
Here, but my certificate is there. But maybe typography error has been offered. My certificate is there.
Yes.
HSLC passed 1990 I passed. The certificate I have.
What is
Yeah.
J? What is J2?
Lordship,
J.
J a junior assistant. My date of engagement 1/3/1996.
1990.
1996. 1/3/1996.
1996.
1996.
Correct.
Date of joining.
Yes.
Then
This was of 3/10/12.
Lordship.
Okay.
Date is 3/12/2010. Then website, in the website, government website, employee's name have been published. My name did not figure.
Where?
Yes. Because my name shown access employees particular school.
See, you do not have a grievance of your name being placed in the access list.
Then
What is your
I am
grievance?
coming. Page 34, immediately form B was directed to submit.
34.
34,
What
format B.
what is this?
This was directed
For re-examination.
pre-submission or review. Since my name did not appear, that's why headmaster also forwarded as per direction of the authority.
So far as you are concerned, review
Yes.
was done.
Review. During pendency of this, my application, provincial list has been published. That is page 35.
35.
35. Dated 20th of August 2013. 2/08/2013.
Order of, this is what,
Lordship, 2013.
what is this order of?
Provincial service of the eligible employees included the respondent number 8 name. Kudeza Begum, bottom table Lordship find serial number 9.
R8.
Lordship, Kudeza junior assistant, date of joining also 4/2/2008.
R8. Okay, then
Lordship. Then I submitted application represent before the director Lordship for challenging the appointment of respondent number 8.
where?
Kudeza.
Where?
That is page 37, 11/2/2015. Prior to that, all the representation,
Okay, representation.
Lordship. My format B application also referred. They did not take any steps in this case. Then I approached the Discrepancy Court.
In the first petition.
First writ petition, WBC 1651.
Yes.
Notice was issued and subject as interim measure subject to outcome of the writ petition. Lordship. Respondent
Have you annexed?
appointment of the
Have you
respondent.
annexed here?
That was not annexed because it was
Okay,
analogous.
doesn't matter. 1651 now?
1651 of
Just
2015. Dated notice 25/3/2015.
Notice of motion.
Notice of motion.
Any further direction?
No, in the on receipt of notice, private respondent entered their appearance. Headmaster, private respondent Kudeza, school management committee jointly filed affidavit.
And R8.
Lawsuit.
Yes.
Stating that my service have been terminated long back 1999.
Yes.
Terminated on 31, showing that termination 31/10/1999 lawsuit. That may be note. Take note. Termination. That is, I have annexed in this, it was page 43.
43.
43. In the affidavit, they came with this document. Your Lordship will find particulars forwarded 2012. I was in service along with them. When I challenged, stating that my service had been terminated, neither informed, nothing, even it does not arise. All have been manufactured only to substantiate the services of the respondent number 8. Nothing else to give benefit. Everything is manufactured. Itself document shows I am in service. Officials document that particular. Another, they contended that I have annexed the certificate, stating that I obtained their certificate for seeking appointment of Anganwadi worker. Very unfortunate. That was that time. Even it was beyond age of Anganwadi worker. All have been manufactured.
We have not understood.
Lost.
Last submission.
Last submission lost it. Another contention of the private respondents, headmaster as well as the private respondent, that one certificate I have annexed. Yes, I am working in the earlier case also. I am continuously. They stating that I obtained that certificate on the ground that I sought for an appointment of Anganwadi worker because of that certificate was
What has that certificate got to do with an Anganwadi worker?
false.
Where is that certificate?
That certificate lost it. My certificate is yes, working certificate, page 52.
52.
52. My working certificate. I am working 2015. And see that my certificate also, I been working. Since the date of joining 1 to till date.
Yes.
Only to accommodate her, their contents on is there. But all the documents subsequently they have been manufactured, there's lost has to be certified. And termination is certified. And the provincial service of the certified, because he has to be the person appointed, there is a seniority as per act has to be considered, and even there has to be a qualification. Age has to be considered also at the time of run. Nothing else. They have been headmaster with a view to give benefit to respond number 8, appointed forwarded documents and
When was the
appointed service.
provincialization done?
Yes, provincialized 2013. Provincialization order lordship 208/2013. Page
Order provincial.
order province page
35.
Page 35.
That is your case.
That is my case. Every
You-
documents have been manufactured.
Your contention, if we can summarize, is that you the services of the petitioners were inducted in 1996,
Yes.
and you joined on 1/3/1996.
Yes.
And your joining was also approved by the IS.
Approved IS.
In 1997,
Yes.
all official documents thereafter
Lordship.
had showed that your name was also sent at the time of consideration provincialization.
Yes.
However, you are not that was not done. In the writ petition, it transpires that there was an order of 1999 itself by which your services were terminated.
Terminated. And another submission is that lordship. After termination, stating that response number was appointed on honorary basis 1999 after my termination.
Response number?
Response number response number 8.
But her appointment was only after expiry of Jalaluddin.
After it was also
2008.
manufactured
2008.
that only to justify that that my service in terminated, she is working since 1999. That has to justify. Another documents manipulated.
Okay, let
Everything are in 2008, nothing else. Stating that time she was Jalaluddin was unable to attend the working managing committee, was directed to appear on her. And even then, after appointing her appointment letter was approved by the inspector of schools after 2008. Even if nothing mentioned in her appointment letter, the approval lordship, page 50.
50.
50.
Yes.
Even the approval letter lordship shows she was appointed in 2008. Approval given 26 to 2008.
So far as Kudeza is concerned, the resolution is 2/28, 2008.
2008.
And 2005 is regard to the other one.
Another person, Shamsul Huda.
Assistant teacher. Additional
Science teacher. So it cannot be said that she was appointed prior to that. And regarding qualification lordship, even if LD assistants lordship 2003 rule 363 section 4, page 360 of this book lordship section 4.
363.
Page 363. Assam Secondary Education Government Service Rules 2003.
2003 rules you are
Three
referring
rules.
to.
Lordship. Rule 4, Section 4, Rules 4, Lordship, method of recruitment.
One second. Three, six, three. Section 4.
Section 4.
Rule 4.
Rule 4. Method of recruitment. Rule 4A, Roman 1.
4. A Roman 1.
Recruitment to the cadre of Law Division Assistant under Rule 3, 2A, 2 and the class 4 post under Rule 3, 2B in the office of the higher secondary school. Higher secondary multiple schools shall be made by directly appointed authority from the select list prepared. Your Lordship, Rule 4, A bottom will find academic qualification. Page 368.
Yes.
Academic, the qualification for direct recruitment for the post of Law Division State in higher secondary multipurpose school shall be higher secondary examination pass or equivalent and having diploma in English and Assamese typewriting. The qualification for the post of class 4 employee shall be class 10 standard. Then age. A candidate for the post of Law Division S10 and class 4 shall be within the age limit of 18 to 36 years. As on the first day of January of the year of advertising for direct recruitment.
Actually, this should have been B.
Lordships.
Academic qualification, I think that typographical error. It should be B.
B, it should be B or
B,
yes,
as
Lordship. It
age
should
is
be
C,
B.
age is
In
C.
place of C, it should be B, Lordship.
No. In place of C, it is C already.
C already.
C is
B
okay.
did not find.
B is academic qualification.
B, yes, one for one B. It will
Because
be yes.
A there are
A,
subsection
one, yes,
1, 2, 3, and 4.
Yes.
Then it should be B.
Yes, it is to be B. Academic is to be B.
Mr. Cartonier,
Yes,
you have
Lordship.
the book. I think this should be B. I think it's a typographical error. I think. If you have the same book, yes, sir. The latest one. This one. Page 368. It starts with 4. Method of recruitment. A 1, 2, 3, 4, 5, and 4. Then academic qualification should be B because thereafter age is C. Age is 18 to 36. Okay.
And then 2011 Act lost its page. This book's page 647.
647.
Yes, Lordship. Assam Venture Education Institution Provincial Services Act 2011.
Yes, please.
Yes. Lordship will find employees, page 653, Act, Section 4, employees to be government servant, and sub-rule 3 of Section 4, Lordship.
Section 4.
Section 4(3).
Just a minute. 4. Four, 3.
4(3).
Yes.
The services of a teaching or non-teaching employee in a venture educational institution up to higher secondary level shall be considered for provincial. Here is the case, he was only HSL.
Hmm?
In the Eastern case, responded by it is only HSL. Even to the 11 Act, he also not.
No, read the later part, it will help you. Only if.
Lordship.
Read the later part also, it
Yes,
will help
yes,
you.
sir.
Only
Yes,
if.
sir. Yes,
Only
sir.
if.
Yes, yes.
Only if.
Only. Yes.
Read the later part.
Provided if an employee is required to acquire any prescribed academic
No, read the entire thing. Why?
the services of a teaching or non-teaching employee in a benchmark education institution up to higher secondary level shall be considered for provincial institution.
Only if
Only if
they have.
the requisite academic and the professional qualification prescribed by the relevant rule at the time of their initial appointment. Yes, that's initial appointment. In case of employees of a degree, that is another aspect. Then section 5, Lordship.
Section 5.
Section 5.
Term.
Terms and conditions of service. Section 5(1). May I read?
Yes.
Subject to the provisions of this Act and the rule made thereunder, all rules, including service rules and the rules of conduct and discipline, which are applicable to state government servants of corresponding ranks, shall be applicable to all employees of educational institutions whose services have been or would be provincialized under the provision of this Act. So 2000 rule has to be followed, and even this Act also says that at the time of initial government has to be requisite qualification. Even provincialization of service of 8 is also illegal.
Yes.
Then your lordship will schedule. The schedule is fine 663
Of the Act
of this Act, 2011 Act.
663.
Yes, 663 schedule. Next page, your lordship will find 664 bottom. Or lordship the top also find high school, high madrasa 2 classes. That preschool was 2 classes.
Where?
Top 6 is 4
Yeah, high school,
categories
high
of institution,
madrasa.
high school, high madrasas, 2 classes.
2 classes.
How much employees to be provincialized?
Yes.
That is the schedule.
Yes.
Only one LDA,
One junior assistant.
only one, with a view to accommodate my name separately submitted arbitrarily behind the back of it.
Yes.
So my submission is the provincial service or responsibility is totally illegal, arbitrary, and non-as in the eye of law, and has to be set aside. And direct me, since I am working, it was eligible, and even eligible till today, my service may be provincialized.
Are you working as on date?
As after getting the notice lost, they debarred me from, I have stated my requisition,
In
they
the
debarred me from attending because of challenge. Headmaster did not allow me. Paragraph 21, lost you will find debarred from attending the school by school managing committee after receipt of notice of WP. Paragraph 21.
When did you receive the notice?
Earlier one they filed
Only in the affidavit,
lost it,
not before that.
not before that. After on receipt of notice, they debarred me.
Affidavit filed in the earlier case.
Earlier case, headmaster along with the private respondent 2015
WBC 1651.
WPC 1651
Yes.
5 and 6 file.
Yes.
Yes. Next one, then separated. Private response separately first, submitted affidavit, and the headmaster separately submitted. Comment did not file any affidavit. This is my case, your lordship.
Government has not filed affidavit in
Not
any
filed.
both
And
the
even the
both the cases.
both the cases, even the particulars forwarded on the day of provincialization for provincial services, it was not denied. And
Yes.
Assuming but not admitting that my service has been terminated. Even if terminated, they have to be followed the rules. That 2007, I have a judgment lordship in this case, in that case only, regarding inductment of wife of headmaster in that school. Exactly similar at the time of provincialization,
Amina Khatun.
Amina Khatun. If their stand is that my service submitted, they have to be followed, but nothing has been followed. That is paragraph 12, 13, 14, 16, 17, 18, and 20. Elaborate discussion.
Paragraph 12.
Paragraph 12, 13, 14, 16, 17, 18, 19, and 20. Elaborate discussion regarding like that.
Yes.
May I read?
No,
Yes. Paragraph 12. Lord.
no, doesn't matter. We've read.
Yes. The respondents have also admitted that the service the
No,
petition was
we've
terminated.
read this.
Yes,
Not read.
this is my humble submission that appointment has provincialization order has to be set aside and direction may be given to consider my case for provincialization.
And the second petition, you're also challenging the termination order.
Yes, Lord, termination also.
Yes. Department. Come this side.
We have received the record, my lord.
This is elementary education.
Oh, that is secondary.
Second.
Secondary, my lord.
Yes.
Yes, my lord. In the record, her name is not there, my lord. We have received the daily attendance register, my lord. Where it has shown that unauthorized absent, my lord.
Who?
I have disputed that.
No.
The
Welcome back.
petitioner, my lord.
You are stating you are submitting from which document?
From the register, my lord.
Register
From
of
the
this,
record.
of the school.
Yes, my lord. Yes,
This
my
is
lord.
not your record. This is records of the school.
Yes, my lord. Record of the school we have received, my lord. Which was called on the earlier date, my lord. And even her name.
Attendance register does not record her name since
No,
when?
madam. This is 1998, my lord. This is the year of 1998, August 1998, my lord.
Since August 1998.
Yes, my lord.
Okay. That is one. What else, madam?
And lordship, we have received one from the year 1999, my lord, in serial number 7, where her name is shown as terminated by resolution number 1 dated 31/10/1999, my lord.
What is that? So this part, I think the school can submit better. What has happened in the school? You have to submit as to the forwarding of the name of the petitioner by the headmaster on 3/10/2012. How did this happen? We'll come to you. See, the name of the petitioners along with others were sent at the time of consideration provincialization. That was on 3/10/2012. In the access, in the list of access teachers or employees, on the same date, the name of the petitioner has been shown.
We didn't receive that record, my lord, at present. It's not there in the record, my lord. Tonight.
Okay, we'll hear the school then. This you are submitting on the basis of school record.
Yes, my lord.
Let the school submit with for the school.
The last question in my honorable court was pleased to ask government advocate to produce the record of the school for the inspectable and the government. So accordingly, it was routed for the inspector to school and for the government.
Okay, this will consider, but you are for the school.
I am for the private respondent.
Who's for the school? Let us hear what the school says. Come this side, madam.
Your lordship, with regard to my
You are for R what?
Yes, your lordship.
R8.
Yes, Alimuddin.
You are
I'm for 5, 6, and 7, your
5,
lordship.
6, and 7.
Yes, sir. And your lordship, this
You are the
affidavit
school
was-
authorities.
Yes, and this affidavit was filed by on behalf of in charge headmaster, your lordship, Alimuddin, your lordship, Alimuddin, and he died on your lordship on 9/3/2019. After filing of this affidavit in opposition.
Doesn't
he
matter.
died, your lordship. And if your lordship considers my paragraph number 2, your lordship,
Hmm.
of my affidavit in opposition, your lordship.
It filed in the later case or first case?
It's for the second case, 2428.
248. Affidavit dated
Your lordship, 26 October 2016.
Alimuddin.
Yes, your lordship.
Yes. Paragraph 2.
Paragraph 2, your lordship. It is correct, your lordship, that a writ petitioner was appointed on 1/3/1996, your lordship.
Where are you reading? Paragraph 2?
In paragraph 2, your lordship, line number 1, 2, 3, 4, 5, 6, 6, your lordship. The writ petitioner. The deponent begs to state that though the writ petitioner was appointed
Yes.
on 1/3/1996 as second LDA of the school, she did not, however, continue her service permanently, remaining absent, unauthorized absent, your lordship, since 1/7/1997, for which several notices were issued to her, but she did not respond at all. Accordingly, the school managing committee of school, following due procedures, as the writ petitioner did not respond at all. Notices were also said in the submission that no notices were served, but notices were served from the school managing authority, your lordship. Several notices were served, but she did not turn over to said notices, your lordship. And finding which the school authority on dated 31/10/1999, your lordship, by resolution have terminated her service, your lordship. And the same was also communicated to her, your lordship, but she did not even protest that time. She never challenges her termination at that point of time, Your Lordship. Again, to Your Lordship, with regard to Khadija, Your Lordship, Khadija's husband, Your Lordship, with regard to my para number 3, Your Lordship, is my para number 3, Your Lordship, kindly pay.
Yes, yes.
The deponent states that by the time the then existing LDA of the school, he was a founder member also, was precariously ill. Hence, the school managing committee allowed the respondent number 8. Respondent number 8 is the present Khadija, Your Lordship, qualified wife of the said LDA, to assist the ailing LDA, her husband, it is Jalaluddin, in the office work. As Jalaluddin was seriously ill, Your Lordship, so to continue the school works, Your Lordship, the school or managing committee have requested her to assist the work, as the present petitioner was absent at that time. In the office work by appointing her on temporary basis by resolution number 1 dated 31/12/1999, and accordingly she started attending the office work virtually, that is from 1/1/2000. Your Lordship, I have also annexed an annexure B, A and B, Your Lordship, regarding the resolutions, Your Lordship. Then come to my paragraph number 4, Your Lordship. The deponent states that the aforementioned ailing LDA of the school, which Jalaluddin, respondent number 8, husband, ultimately died on 26/12/2007. So respondent number 8 then applied before the managing authority for her regular job on the school on humanitarian grounds. Considering her setback, the school managing committee of the school, considering her prayer and her application in the office work since 1/1/2000, formally appointed her on 2/2/2028. So Khadija was appointed on 2/2/2028 formally. Before that, on honorary basis, she was taking in the venture school. Next to my paragraph number 5, Your Lordship, the deponent states that thereafter the service of respondent number 8 was duly provincialized as per the Act and rules, along with the other staff of the said school, and she has been continuously serving as such and getting a salary regularly. Then paragraph 6, Your Lordship, that the deponent further states that the writ petitioner whose service were as stated above are discharged long back on 31/10/2099. Annexure 12 of the writ petition did not challenge her protest against the same, though she was duly communicated and well aware of. Unfortunately, now long after the service of the respondent number 8 have been lawfully provincialized along with the staff of the school, the writ petitioner, with ulterior motive of unlawful and illegal gain, most cleverly by misleading the outgoing headmaster for an experience certificate. That also she have asked me that I am going to apply for Anganwadi, Your Lordship. So on that basis, on humanitarian ground, that certificate was issued, Your Lordship.
Now, why is the certificate for Anganwadi required?
He have stated that to prove my service that I am regular in, I am a good teacher. I am having experience.
A teacher
I am
will,
having experience. Your
teacher
Lordship.
will leave his post to become Anganwadi worker.
Some experience certificate. Cheer told me.
Teacher will leave his post or her post to be an Anganwadi worker.
Yes, Your Lordship. He wants to continue in some service and also for that reason, Your Lordship.
Difficult to accept, madam. Okay, what else?
That much, Your Lordship, as per my
Two questions. Now, did the respondent number 8 possess the qualification as per the rule? Number 1. Please have a seat, we'll have a chance. Number 2, why was the name of the petitioner forwarded at the time of provincialization? You have said nothing in the affidavit.
Your Lordship, that list that was forwarded, as per record, the name where petitioner's name were shown, that list was not forwarded by us.
Where have you stated?
It has not been stated in
You have
our
not stated anything. Number one. Number two, did the respondent by it possess the necessary qualification?
Your Lordship, since she was unauthorizedly absent, Your Lordship.
That we are not on that. Did the respondent by it possess the necessary qualification of being a higher secondary? Did she possess the age which is required to for a candidate to be eligible for entry into the service? What is the qualification of respondent by it?
High school living certificate.
High school.
And she was appointed originally in 1999.
No. What is the requirement in the rule? HS.
By the time she was appointed, it matriculate now. It in 2003 only it became higher secondary. And it came in effect from August 2008, my lord.
When the provincialization was done, qualification will be taken into consideration.
She was an existing staff of the school.
Doesn't matter. Did you possess the qualification?
Qualification high school living certificate. She was initially appointed.
Your continuation will be difficult.
She was initially appointed in the year 1999.
That was at a venture stage. In a provincialized school.
And she was continuing as an existing staff, my lord. And she was regularly appointed in 2008.
2008, yes. 2008 regularly appointed and provincialized when?
Provincialized in 2013.
At that time, higher secondary is not required.
I think they required, but she is an existing staff. As per the act, my lord, she is an existing staff of the school.
All existing staff, irrespective of all existing staff, irrespective of the qualification, can be accommodated as government servant.
If somebody is lacking, my lord, there is a provision that she should be given the chance for obtaining.
From 2008 till 2023, did you possess the higher secondary?
That was not perhaps stated in the required, was not.
This school has not even denied that the name of the petitioner was forwarded.
No, yes, my lord.
Only certificates part they have said that it was given on the request of the petitioner. For the time, let us assume that it is correct. What about the list?
My lord, in the earlier petition affidavit has been filed in detail. Actually, these things, my lord.
Earlier petition affidavit, if you go to that affidavit, you will be in real difficulty. Authority, beneficiary, all filing a common affidavit.
By that time, ignorantly filed was filed, but in the second petition.
If that is why we are saying we are asking you, if you revert back to the affidavit filed in the earlier case, your entire case will be gone.
And only thing, my lord,
You take side with the beneficiary. You are the authority.
Only thing I get to place is for the law.
Yes. You make your submission. Anything, madam? Anything else?
Your Lordship, the list that my petitioner was showing, Your Lordship, that page number 30, Your Lordship.
Yes.
That is also been, if that list was forwarded by the school managing authority, then shame had been present in the school record also, Your Lordship.
What are you saying?
That has been manipulated.
Where is your stand?
That has been manipulated, Your Lordship.
Where is your stand? What else submission will do with this kind of a serious allegation? What prevented you from stating this on the affidavit? Not even a whisper? One line would have been enough that we have not sent the name of the petitioner. Matter ends there. You have not said anything. We have read the affidavit, we have not found anything. If there is anything, please show us. Yes, Mr. Rajbhai.
My lord, indeed that my lord, my land friend is saying that she was appointed as the LD assistant, second LD assistant, correct. She
Here
was-
for
he-
response number
I have for response number 8, my lord. She was appointed, the petitioner was appointed genuinely, of course, in the year 1996. And after continuing for 2-3 months, as per my information, did not continue. She did
See,
not-
you as the beneficiary, you will not have much role
Of course.
on the to say about the petitioner. You can defend your case.
Yes, well. So
You
my
say
case-
about your
my-
possess-
My case is, my lord, on the base of the materials available in his record, my lord.
Mm.
Your lordship kindly see.
Yes.
The read petitioner was terminated from the school. Page 38, madam, annexure 11 of his read petition, of which he has now challenged in 2016. This is the resolution dated 31/10/1999, my lord. That, my lord, the secretary of the school applied to the house that Srimati Salia Lashkar, who was at placed as LDA, second of the school, to assist Jalaluddin LDA, but she remained absent since 1797. Till date, in spite of her several notices, Toko's notices, etc., but she has not responded till date. After a long discussion about the absentee, many unanimously decided to discharge her from Salia Begum Lashkar, second LD of the school, with effect from today, that is 1/11/99. The committee finds with deep concern that the distressed conditions of the school building and requested the secretary to move the local MLA to.
This is not required.
This is not required, my lord.
2 and 3 not required.
Then, my lord, kindly see her termination order, annexure 12, page 43. Srimati Salia Begum Lashkar LDA, second wife of Sharifuddin Lashkar of village Gonigram, Pure Gonigram district, Kachar, is hereby terminated from her service for non-reply of the notices dated so and so regarding unauthorized absence from duties by resolution number 6 dated 31/10/99. Then, my lord, your lordship kindly see. Then there was a meeting, annexure 13, page 44, my lord.
Yes.
Page 44. The meeting is presided over response. The headmaster of the school placed the application received from various candidates for appointment of LD. Second, for long suffering illness of Jalaluddin, existing LD, who is unable to run the official work after proper scrutiny. 3 petitions found eligible. Anwar Begum Talukdar, Khudeja Begum, Aftabuddin Lashkar, claiming appointment of LDA. Honorary basis is post candidates are interviewed. All the candidates except Khudeja Begum are not willing to work without remuneration. The school is in venture stage and fund does not permit any payment to LDA second. Srimati Khudeja Begum agrees to work on honorary basis. So the MC unanimously reserved to appoint Srimati Khudeja Begum second LDA on honorary basis with immediate effect. The Khudeja Begum happened with the wife of Jalaluddin Lashkar, the regular LDA.
Yes.
He was not keeping well, my lord. He was physically handicapped, paralyzed type. So she would always accompany her husband in the school. Ultimately, she was honorary given the appointment because Salia Begum was not coming. The petition was not coming. Then, my lord, your lordship kindly see annexure 14, page. Subject to discharge without assigning any reason, Srimati Khudeja Begum, wife of Jalaluddin Lashkar Tarinipur, district Kachar, is hereby appointed purely temporarily on honorary basis for the post of LDA in Tarinipur High School, Sialtek, Kachar, by resolution number 1 so and so 31/12/99 with effect from 1/1/2020, madam. Then that appointment was approved by the inspector of schools, my lord. That is page 15. Subject to discharge without assigning any, there are Srimati Pureza Begum, school, high school living first past life is wife, late of Jalaluddin LDA, is working on honorary basis since 1/1/2000. He is hereby appointed as LDA 1 against the vacant post of Jalaluddin who died on 26/12/2007. Her husband died on 2007 by NMC resolution number so and so on 2/2/2008. Then she was in continuation of her honorary appointment. She was regularly appointed on my lord 4/2/2008. This is the appointment letter, my lord. And then it is also mentioned in the particulars submitted before the government. And then my lord, resolution approval letter of the inspector of schools. The action of the managing committee of Taranipur High School, Pure Sialtek, as adopted by resolution number 1, held on 2/2/2008, number so and so, and held on 22/9/2000, respectively, appointing following teaching and non-teaching staff with effect from the date of their joining, mentioned against is hereby approved. This was the approval given by the inspector of schools, P. Kolita, the appointment of Pureza Begum, madam. Then, my lord, while the school was provincialized, in the year 2013. The writ petition was silent. She was not written. She did not protest about her initial termination, as I have read out my in 1997. Then, when the school was provincialized, she was hobnobbing with the then headmaster, Alimuddin, who is no more. And then what happened, my lord? He pursued the inspector of schools, sir. I may be giving a certificate, that of experience certificate. The headmaster, of course, is dead by now. I don't know whether.
How do you make this submission?
No, my lord, it is mentioned in the affidavits I received from my learned friend.
That part has already been
My lord.
stated, but
And on this basis, my lord, in 2015, she filed a writ petition. The school was provincialized. The school was provincialized on, as per the director's order, my lord, and page 30, page 33, my lord, page 33. Page 33 is the government order, my lord. Proposal in the school, then the director issued the formal order, page 35, my lord, 20th August 2013. 20th August 2013. This is the order issued from the directorate. The name of the respondent is shown at serial 9, page 35, my lord, of his writ petition.
Yes.
This order was the order after the government's declaration. Director issued the order dated 28/2013.
right.
Page 35, my lord. Then writ petitioner filed an application to the inspector of school, her annexure, page annexure 10, dated 11/2/2015.
Yes.
11, after about 2 years, she filed an application to the director, that to the through speed post. And thereafter, she filed a writ petition, my lord, claiming her appointment, her service in 2015. Claiming that she was appointed and she has been continuing in the school record. My lord, the learned government advocate has brought the record before the lawsuit, my lord. The school record does not show that she was at all appointing in the schools, my lord. Whereas the writ petition, present respondent number 5, who was initially working since 2000 and formally appointed after her husband's death, who was the first LD of the school as a regular LD. He was honorary or second LD, and she was appointed in 2008. And the school was getting the financial aid from 2008 and 7, my lord. The school record as a acquaintance register as I received from my learned friend, my lord, does not show the name of the petition. And my learned government page is also telling, my lord, as for the school attendance register, since the year 90, latter part of 97, she is absent. She is not in the school book. Now, my lord, my learned friend has shown your lordship, drawn a lordship attention, showing a B form. The B form is not at all submitted by the headmaster of the school. It is a manufactured one.
Now, how can you say that?
Because
You are the
my lord,
candidate.
of course,
They have not said anything.
Of course, I need. I may not submit it, my lord. But
No,
as
you
per-
don't have the, you cannot say anything about B format, whether it was served or not, submitted or not.
So my learned government will produce record.
Your colleague has not said anything about B
They will,
format.
government advocate will play this record.
Government, it's not within the government. See a direct look at this page 34. It contains the forwarding by the headmaster on 24, 2013. It was received by docket number 298.
So, my lord, whether government records has contained this paper.
This is
your
not a
lordship may
government
kindly please
record.
examine.
This is not government, this is a school record.
The school record, it has to go to the government, my lord. To the director.
What have you sent to the director? We do not know. The presumption is against you. Your conduct in the very first petition was not at all proper. You took side with one of the beneficiaries. You cannot. You are the authority. You may defend your action.
Of course.
You can definitely defend your action. You are entitled to. But filing a common affidavit.
Second, of course, see, it has been corrected in the second time, my lord. See, the individual appointment affidavit has been filed.
Madam has not said anything about format B in the affidavit. She has not denied the allegation that the termination order was received only in the affidavit of the first petition. Our paragraph 14 is absolutely evasive.
Now, my lord, response number 8 submission is there, my lord. He has been genuinely appointed.
What about your education qualification? You still say your high
My
school?
lord, as for her qualification, as she is telling, my lord, by the relevant time in 1999, she was given the honorary appointment.
At that time, it was it was a venture school.
And venture school.
Venture school.
Then the school was provincialized and she was an existing staff of the school, my lord. As per the 2011 Provincialization Act, my lord, your lordship kindly see. Employees, my lord, page 649, my lord. Employees means and includes all serving employees, both teaching and non-teaching.
You are referring to page?
Page
649,
man.
649.
649.
Yes.
Employees means and includes all serving employees, both teaching and non-teaching of venture education institution who have been appointed by concerned venture education institution before the first day of January 2011 and whose services are being or would be provincialized under this. So she was appointed long back, as I placed before the lawsuit, in the year 2000 and by the resolution dated 99, December 99 and on honorary basis. And then after her husband's died, having died in 2007, she was formally appointed. So by the time she was entered.
No, why have you referred to the definition of employee?
My lord. Definition of employee, my lord. 649.
No, you have referred to the definition of employee, 2H. For what purpose?
She is an employee of the school, my lord, has entered
No,
venture school.
That is not denied.
And that venture school has been taken up by the government.
No, you are to respond to a query by the court regarding the qualification.
Yes.
But what is your response?
The qualification, my lord, qualification question of qualification came in 2003 Act rule, my lord. Your lordship kindly see page 363, my lord. Assam Secondary Education Provincial Service Rule 2003.
Yes.
At page 363, my lord.
Yes.
The Gazette notification dated 8 August 2003. 8 August 2003, my lord. The rules they came into in 364. Your lordship kindly see section 2. They shall come into force on the date of their publication in the official gazette.
Yes.
It was the gazette notification was the 12th August 2003.
Yes.
So this restriction came providing qualification as higher secondary also, my lord, came in 2003 only. But whereas the respondent number paid, as I have drawn your lordship kind attention, she was honorarily appointed by resolution 31
Yes.
31/12/99, my lord, and her appointment was, as I have drawn your lordship attention, not by her affidavit, but even on the paper submitted by my learned friend, my lord. She was appointed by Annexure 15, page 49.
Yes.
It speaks about her earlier honorary appointment, subject to discharge without assigning any reason thereof. The Kudezara Begum High School Living Certificate passed typist, wife of late Jalaluddin LDA, who is working honorarily since 1/1/2000. He is hereby appointed as LDA against the vacant post of Jalaluddin Ahmed and the LDA of the school, who died on 26/12/2007. That is in December 2007. Then she became regular. Before that, she was appointed, page 14, my lord, page previous next year, in the on 31/12/99. So by that time, she was matriculated, she was qualified, my lord. She continued the existing staff of
But even if we take your government,
my
test your government, the submissions made right now. That at the time of,
her affidavit, my lord, you also can.
no, you say that her appointment was finally in the year 2008.
Fine, regularly made in 2008. In continuation of our honorary service.
See, there cannot be two LDA in a school of this nature.
No, by the time she was initially appointed, she was assisting her.
She was only assisting her husband.
Yes.
It was an arrangement. Even if we accept your submission.
Petitioner was also a second LDA, my lord.
But yes, understood.
With Jalaluddin.
But after the death of the Jalaluddin, post was vacant.
Then
Now-
there was then she was taken as a regular candidate, my lord. On honorary basis, and because on empirical ground, since he has been continuing, her husband was the founder LDA, who ultimately died in harness even before provincialization of the school. So my submission, my lord, right from the she was regularly appointed in 2008, and your lordship will be pleased to see the equipment register whereby the financial assistance was provided by the government. In the papers, it contains the name of Kudeza Begum as one of the recipients along with other staff, whereas there is not name of the Saleh Begum at all, my since the year, admittedly from records in the year 2008, my lord. And as for the affidavit submitted by the respondent 8, and as my learned friend on behalf of the headmaster stated that the Saleh Begum was long back terminated. She was not in the school. Subsequently, perhaps after the school was provincialized in 2013, she first submitted the representation to the inspector of school director in 2015. Then she came on to the petition 2015. And after the detailed affidavit is filed for explaining the matter, she now challenges the resolution of 99 in the year 2016 in the writ petition, and termination of the writ petitioner, her appointment, this thing, which was done long back. He was not in this school. Now, my lord, I respectfully place before a lawsuit my learned government friend, as they have brought whatever record for the school to the inspector and the government. It has been come to them through a government. So whether the name of Saleh Begum is seen in the attendance register or there is in other papers of the school, your lawsuit kindly verify. And my submission, my lord, your lordship is of course not allowing. She manufactured the case after obtaining certificate from the headmaster in 2015. Whereas the appointment, provincial order issued from the government in 2013, and she even filed a representation in 2015. Not immediately, there is a provision to file appeal this thing, she did not do this thing. Just for making of the case, she made this paper smile. And as for my information, subject to correction, my your lordship, that the papers now she managed from the outgoing headmaster, of course, who is no more now.
You should have put this on an affidavit.
My learned friend may file the affidavit while in this respect, if necessary. Of course, he has filed.
2016.
2016.
So lordship, permit me, I may file an additional affidavit. So I am not,
Matter of 2016, you'll file now.
oh, your additional.
And after the hearing is over. Sorry. Yes. Anything else? Reply.
Lordships, regarding an
Complete it.
yes, yes.
5
Against
minutes.
there two affidavits, I submitted affidavit reply. In both the cases, affidavit in reply submitted against the affidavit of 567. It was dated 4/1/2018.
Yes.
That I denied totally paragraph number 4. This was private respondent Saleha Begum. A reply to lordship, my reply against affidavit 567 was filed by yes 567 filed by Alimuddin headmaster. Against that, I submitted my reply.
Okay.
lordship.
Okay. We'll
Lordship,
anything
yes.
else? Anything else?
And regard annexer 15 lordships regarding appointment letter. 8 and 53. Regarding my learned friends stated that I have submitted after 2 years, that won't be immediately, and that has also been referred in my representation. Regarding her appointment lordships, annexer 15 of my writ petition, page 49. It was I got from their affidavit in the earlier case,
She is not in the school, man. How can she get?
and in that appointment letter of respondent number 8, even what is stated, she is to join within 7 days. Even if she has been there earlier, why further joining is required? This was also manufactured. That was not the original appointment letter.
We'll come back. We'll pass the order.
Yes.
We'll over.
My lord will be pleased to see the records, my lord. Just want to place before the lordship, my lord. The rule my learned has been pleased to place before your lordship. It speaks about 2003 rule, my lord, page 368.
368.
368, last, my lord, academic qualification. The qualification for direct recruitment, my lord, page 368.
Right.
It is for the qualification place for the direct in case of the direct recruitment. And also your lordship kindly see at page 369, my lord, age, a candidate for the post of lower assistant and class 4 shall
be
69
within
the age limit of 18 to 36 years on the first day of the January of the year of
which page are you-
advertisement.
which
Page,
is the-
page 369, my lord.
Yes.
In the, your
Age,
lordship, C,
age,
your
C.
lordship is correct, it is to be B.
Yes.
It is C here.
No, it is
Age
C.
18 to 36.
Academic qualification should be B. This is
It should be B. On the first day of the year
Mr.
of
Asbabria.
advertisement.
this is correct. This is C only. The earlier should be B.
Then, my lord, if it is C, then, my lord, the age is 18 to 36 years, age on the first day of the year, January of the year of advertisement for direct recruitment. So it is in case of the direct recruitment. And another
This is
thing,
not direct recruitment.
Indirect.
direct recruitment, my lord, existing term. See,
What is the difference between a direct recruitment?
direct
What is the
recruitment,
meaning?
there should be an advertisement against the vacancy, then for the application will be submitted.
Direct recruitment is directly into not a promotion. This is the promotion.
It is not a promotion, of
Then-
course, my lord, but continuing in the service. And my lord, kindly see page 649.
649, yes.
649. District Scrutiny Committee. 649, my lord.
Yes.
District Scrutiny Committee means the District Scrutiny Committee constituted under Section 10 for each district to recommend the names of the venture educational institutions which are considered eligible for a formalization of the services of the employees serving therein.
649, which
Of the 2011 rule, my lord.
649?
649, my
Okay, 1 second.
lord.
Yes.
District Scrutiny Committee against G, my lord.
Just a minute, let us note. Yes, please read.
District Scrutiny Committee.
Hmm.
G against G, my lord. District Scrutiny Committee means the District Scrutiny Committee constituted under Section 10 for each district to recommend names of the venture educational institutions which are considered eligible for commercialization of the services of the employee serving therein. Service of the institution formalization. It is not a question of direct recruitment or indirect recruitment. Or then definition of employees I have read before your law. She was an employee of the school with the qualifications what she have, and by the time she was working there, she was qualified. So this
Qualified means she possessed higher secondary.
she is matriculate and typewriting certificate.
You said that she by working she become qualified. Did she obtain higher secondary during her tenure?
No, the higher secondary she did not. Matric and typewriting matter. And the school authority utilized her service since the year 1999.
These two writ petitions have been instituted by the same petitioner.
Yeah.
Also, while the first writ petition, WPC 1651 2015 had been filed, was filed, mainly challenging the action of provincialization of the service of the respondent by, please hand over the record of the respondent by 8 as junior assistant in the Tarinipur High School in the district of Kachar, the second writ petition, WPC 2428 2016, has been filed or was filed challenging an order of termination of the petitioner from his services made in the year 1999. Full stop. Before going to the issue, which issues which have arisen for consideration, comma, the facts of the case in brief may be stated as follows. Para. The Tarinipur High School, within bracket here in the school, bracket school, was established in the year 1959 and had got recognition from recognition on 1/1/1990. Also, the petitioner claims that he possessing all the requisite qualification was appointed as LDA in the school by an order dated 28/2/1996 issued by the managing committee after a resolution. Pursuant to the same order, comma, the petitioner claims to have joined the school as LDA, within bracket junior assistant, on 1/3/1996, which was also approved by the Inspector of Schools, Qatar, on 31/3/1997. The school, comma, it may be mentioned, was at the venture stage at that time. Para. The petitioner has stated that that one Jalaluddin was working from prior point of time as an LDA, and it was only to assist him that the petitioner was appointed. However, comma, the said Jalaluddin had passed away on 26/12/2007, whereafter the respondent number 8, who was the wife of Jalaluddin, was appointed on 4/2/2008 by a resolution. The petitioner claims that the respondent number 8 was more than 41 years of age at that time and was only a matriculate. It is the case of the petitioner that after the enactment of the Act of 2011, comma, on 3/10/2012, comma, the headmaster of the school had sent the particulars of various teaching and non-teaching staff to get the benefit of provincialization. The said chart also contained the name of the respondent number 8, which itself records that she was 47 years of age and had joined the school on 4/2/2008 with qualification as HSLC. since the name of the petitioner was left out, comma, on the same date, that is 3/10/2012, comma, another proposal of excess employees was forwarded by the headmaster containing the name of the petitioner, whose detail was also given. Full stop. The petitioner was shown to be working as a junior assistant dash Roman 2 with where are you? Roman 2 full stop. Though in the qualification column, comma, the petitioner has been stated to be an HSLC pass candidate, comma, the learned counsel for the petitioner has submitted that the same entry is apparently is an inadvertent error in as much as the petitioner has passed his higher secondary examination, the testimony of which is also annexed with the writ petition. Full stop. Para. It is the case of the petitioner that since the government website did not figure his name, comma, he submitted representation for review. Full stop. However, comma, in the impugned order of provincialization dated 28/2013, comma, the name of the petitioner was not present, whereas the same contains the name of the respondent number 8 as junior assistant. Full stop. The petitioner claims to have submitted a representation and claims to have submitted representations, including one dated 11/2/2015, whereafter the first writ petition WPC 1651/2015 was filed. Full stop. Para. In the aforesaid, in the first writ petition WPC 1651/2015, comma, notice of motion was issued by this court on 25/3/2015, whereafter a joint affidavit has been filed by the headmaster, comma, school management committee, and the respondent number 8, wherein it has been stated that the service of the petitioner was terminated in the year 1999 itself, comma, to be precise, on 31/10/1999. Full stop. The petitioner had accordingly filed the second writ petition WPC 2428/2016 against such termination order by contending that the same was never communicated to him and also not preceded by any contending that the same is a manufactured document, as he was all along working till the filing of the writ petition, only whereafter he was debarred from discharging his duties. Also, Sarah, I have heard Sri F.U. Borbhia, learned counsel for the petitioner. Also, I have also heard M.S. S. Terangpi, learned standing counsel. Secondary Education Department. Also, Sri Madhavbhia has appeared. Sorry, Amateur Asbar Bhuya has appeared for the before MS R. Begum has appeared for the School Management Committee, namely respond numbers 5, 6, and 7, whereas Sri M. H. Rasbar Bhuya has appeared for the respond number 8. MS Terangpi, the learned standing counsel of the department, has also placed before this court the record obtained by the directorate from the concerned school and the office of the inspector of school, Kachar. Also, the rival submission advanced by the learned counsel for the parties have been duly considered. Sri Borbhia, the learned counsel for the petitioner, submits that the impugned action is vitiated only to deprive the petitioner and to give benefit to the respond number 8. Also, he submits that there cannot be any doubt that the petitioner was in service as which should be reflected from the forwarding of the names by the headmaster of the school on 3/10/2012 in the list of access teachers. Is it access teachers?
Yes.
Access employees.
Excessive.
Access employees.
It is shown as teacher, my lord, not an LD. So it is doubtful, my lord, your lordship kindly see.
No, he's the
As-
junior assistant.
No, my lord, in the paper she has shown her name is, it
Junior
is-
assistant. Taleha Begum Luster.
my lord, your lordship may be pleased to see.
We have seen page 32. Page 32 we have seen.
Page 32, my lord. Page 32, your lordship, in the light column, classical teacher, language teacher, assistant teacher, non-assistant teacher.
That is the
One-
format. What has been given as particular J2.
Again, the column of teacher, it is written J.
Maybe column is not important. What is the particulars given?
It is J2, my lord.
Then and see in the not in the row. You see in the column designation, headmaster, assistant headmaster, teachers, classical teachers, Sanskrit, assistant, grade 4, etc. Everything. Column number 5.
Then your lordship kindly see, disturbing your lordship in the
We are
page,
dictating.
paragraph, page 30, my lord.
You are dictating. Please do not disturb now.
Page 30, your lordship kindly see.
reflected from the list of excess employees, which was forwarded on 3/10/2012, containing the name of the petitioner. That apart, he also submits that in the format B, which was also forwarded by the headmaster in the year 2000, in the year 2013, would show that the petitioner was in service. Full stop. Para. With regard to the eligibility criteria, the learned counsel has drawn the attention of this court to the rule of 2003, page 363 of the book, and has referred to rule 4 within bracket B and 4C. Full stop. Rule 4B stipulates that the qualification for holding the post of junior assistant should be higher secondary, and as per rule 4C, the age has been stipulated to be 18 to 36 at the time of entry into the service. Full stop. Reliance has also been placed on the Act of 2011, page 647, and reference has been made to section 4 pertaining to employees of government schools. Full stop. He submits that under section 4 within bracket 3, the conditions for provincialization has been laid down, wherein it has been stated that the candidate should possess the requisite qualification at the time of initial appointment. Full stop. Section 5 has also been pressed into service, which lays down the terms and conditions are of all rules, which lays down the terms of condition as per which, all rules are required to be followed. Full stop. The schedule of the said act has also been referred to, wherein, so far as junior assistant is concerned, only one junior assistant is prescribed. Full stop. The learned counsel submits that it is only for this purpose that the petitioner has been deprived to give undue benefit to the respondent number 8, who is otherwise unqualified. Full stop. Para. As regards the second writ petition, wherein the order of termination dated or termination in the year 1999 is challenged, the learned counsel for the petitioner has submitted that such information was received for the first time only from the affidavit in opposition filed by the respondents in WPC 1651/2015. Full stop. he submits that the affidavit was a common one filed by the school authorities as well as by the beneficiary, respondent number 8, and that by itself would establish the connivance. Full stop. By referring to the averments made in paragraph 14 and 21 of WPC 2428/2016, the learned counsel has submitted that at no prior point of time the notice of termination was ever issued or brought to the notice of the petitioner, and the same was received for the first time along with the affidavit filed in the earlier writ petition by the respondents. Full stop. He has also submitted. He has the learned counsel has also submitted that specific averments have been made, that the petitioner has been debarred from attending his work after filing of the case. Full stop. Para. The learned counsel for the petitioner submits that apart from the fact that the termination order is unsustainable in law and was never served upon him till the same was brought to his notice by way of an affidavit, as stated above, the same is otherwise not legally sustainable, as the same was not preceded by the due process of law. Full stop. No inquiry of any nature was conducted, and no opportunity was granted to the petitioner before such termination order was issued. Full stop. This submission has been made without prejudice to the earlier submission that the said termination order is a manufactured one and therefore non-est in law. Full stop. In this connection, the learned counsel has also relied upon an order dated 8/3/2017 passed by this court in the case of Masammat Amina Khatun in WPC 4800/2011, wherein in similar circumstances, this court had interfered with order of termination. Full stop. Para. For contrast, MS Terranpi, the learned Training Council, Secondary Education Department, has submitted that as per attendance register received from the office of the Inspector of Schools, Kachar, which were in turn procured from the school, the name of the petitioner does not exist since August 1998, and therefore it could be presumed that the petitioner was not in continuous service. Full stop. The learned Training Council, however appears that no affidavit has been filed by the department in either of the two cases. Full stop. Para. MS R. Begum, learned counsel appearing for the school authorities, namely the respondent was 5, 6, and 7, has submitted that since 1/7/1997, the petitioner was unauthorizedly absent, and accordingly, his services were terminated after issuing notice. Full stop. He further submits that though the services were terminated on 3/10/1999, there was no challenge to the same until filing of the second writ petition in the year 2016, and on the ground of unauthorized delay itself, unauthorized, on the ground of inordinate delay itself, the writ petitions are liable to be dismissed. Full stop. By referring to the affidavit in opposition filed by the respondent numbers 5, 6, and 7, the learned counsel has submitted that the earlier incumbent holding the post of LDA, one Sri Jalaluddin, was unwell, and therefore the respondent number 8, who was his wife, was allowed to assist in discharging the duties by making a temporary appointment on 31/12/99 on honorarium basis, on honorary basis. Full stop. She submits that in the year 2007, he died?
Yes, sir.
7, the earlier LDA passed away, and subsequently by an order dated 2/2/2008, the respondent number 8 was formally appointed. Full stop. By referring to the averments made in paragraph 6 of the affidavit, the learned counsel has submitted that specific plea of delay has been taken. Full stop. Para. Defending the impugned action, Sri M.H. Raj Borbhia, learned counsel for the respondent number 8, has submitted that the resolution for termination of the services of the petition was in the year 1999, which has been put to challenge only in the year 2016. And on the ground of delay itself, both the writ petition, on the ground of delay itself, the second writ petition ought to be dismissed. Full stop. He further submits that since the petitioner was not in service from 1999, the question of considering her case for provincialization would not arise at all. Full stop. Para. The learned counsel for the respondent number 8 submits that after the termination of the services of the petitioner on 31/10/1999, there was a need to assist the existing LDA who was unwell, and accordingly, his client was inducted in the services to assist in the work of the LDA by the school managing committee by a resolution dated 31/12/1999. Para. So far as the qualification is concerned, the learned counsel submits that the respondent number 8 was an existing staff And therefore, the qualification which has been prescribed in the act which came later into operation may not be applicable. Full stop. He otherwise submits that his client is a matriculate and is having the experience to handle the work of a junior assistant. Full stop. Para. Reference has been made to the definition of employee inverted commas, appearing in section 2 within bracket H of the Act of 2011, and also the rules of 2003, wherein qualification has been laid down. Full stop. He submits that such qualification came into existence only in the year 2003, whereas the respondent number 8 was working since 31/12/1999, and therefore there may not be any strict requirement of the qualification prescribed subsequently. Full stop. He further submits that the records would reveal that the petitioner was not continuing in his service, and full stop. He also submits that the statutory rules prescribed for preferring of an appeal, which has not been done, and therefore on this count also the writ petitions are not maintainable and liable to be dismissed. We'll dictate in the second half. There is a full court meeting. There may be some delay also in पहले हमारी जो बात कहीं पे कुछ बात करें उससे कुछ सबमिशन पर पहले he has some difficulty.
Well, next week, Malad, any date.
Next week.
Monday or Wednesday.
Malad, any date.
Item number
34.
yeah, for which respondent?
Malad, I am the for the statement.
Okay. Of the main list or supply list?
No, main list, Malad. 34 after admission, Malad.
Bail matter.
Yes, Malad.
What is the difficulty, Mr. Sharma? I have to leave.
Yes, Malad.
Oh.
Next week, Malad.
10 copies have come otherwise.
Yes, Malad. Come, Malad. I have checked.
Sri Sharma, the learned additional PP, submits that due to some personal difficulty, he has to leave the court early. This case on Wednesday next date to depart.
May please, Lord.
Yes,
Item number 7. Already Bishina left for his personal difficulties. So let matter
7 daily leave.
Yes. You are mentioning on whose behalf?
Bishina, Lord.
Bishina, okay. Oh. Other side is there.
Yes.
We had called this matter in the morning, I think.
Yes. Other side was not there, Lord. It is time being passed.
Okay. As agreed to by for the 16th matter, Tuesday next. Tuesday for disposal.
Maybe Monday or next Monday.
Monday. Then.
Monday.
A prayer for adjournment has been made by the parties, by the learned counsel for the parties, considering that this writ petition is pending since the year 2016. A short accommodation is made, directing listing of this case on Monday next.
Obliged.
It after line to case. Oh, ঠিক আছে. Uh, rejoining his submission, comma, re FU board via learned counsel for the petitioner contends that apart from the fact that the crucial averments made in the red petition, averments made in the red petition have not been denied, comma, the petitioner has also filed reply affidavit in both the writ petition. Full stop, para. The rival submissions made by the learned counsel for the parties have been duly considered, and the materials placed before this court, including the record presented by the department, have been carefully perused. Full stop. Though writ petition W4 2428 2016 has been filed in later point of time, comma, since the same is on the subject of termination of service of the petition and the comma, the adjudication of which would have a material effect on the subject matter of the first writ petition, comma, the same is taken up first. Full stop. Para. The petitioner has challenged the order of termination of service which was passed in the year 1999. Full stop. Such challenge had to be instituted after coming to know about the same order from an affidavit filed jointly by the school authorities and the respondent number 8 in the earlier writ petition WPC 1651 to 2015, which was qua the provincialization of the services of the respondent number 8 by depriving the petition. Full stop. The petitioner has made a categorical statement in paragraph 14 of the writ petition, wherein it has been stated that at no prior point of time, comma, he was given notice, he had noticed or was issued a copy of the termination order dated 31/10/1999, and it was only from the affidavit filed by the respondents in WPC 1651 2015 that he, comma, for the first time came to know about such termination order. He is the she lady. She. Full stop. For regi reference, comma, the averments made in paragraph 14 of WPC 1651 2015, of WPC 2428 2016 is expected herein below. The aforesaid averments have not been denied by the department, as no affidavit has been filed by the department in either of the cases, which has already been recorded above. Full stop. In the affidavit filed by the private respondent, comma, the averments of paragraph 14 has been replied in paragraph 6 of the affidavit in opposition. Full stop. A reading of the state opposition which is extracted herein below. Paragraph 6 of the affidavit in opposition. Page which is expected herein below. Full stop. A reading of the state state reply would show that there is no denial of this fact, and in fact, comma, the state issue has not even been dealt with. Full stop. Therefore, comma, this court is left with no other alternative but to come to a conclusion that termination order dated 31/10/2099, if any, was never served upon the petition. Full stop. Para. It is a settled law that orders, until and unless it is communicated, will not take effect. And in the instant case, comma, the contemporaneous material would rather show that all along, comma, the petitioner was continuing in his service. Full stop. In this regard, comma, there is no denial from any of the respondents regarding forwarding of the name of the petitioner on 3/10/2012 for the purpose of provincialization of her service. Full stop. Though an objection has been raised with regard to the certificate produced by the petitioner, that such certificate was issued on the request of the petitioner for some other purpose, comma, even ignoring the said certificate, comma, the materials on record establishes that the petitioner was in service. Full stop. Para. Though the F.U. Borbia, the learned counsel for the petitioner, has also assailed the termination order dated 31/10/1999 on merits, with the submission that the same was not preceded by the due process of law, comma, the said aspect of the matter need not be gone into in view of the findings arrived at by this court, that the impugned order of termination is otherwise not sustainable. Full stop. This court, however, would observe at this stage that no semblance of any prescribed procedure is seen to have been followed before issuing the termination order dated 31/10/1999, as the same appears to have been done without any inquiry or giving appropriate or giving adequate opportunity. Full stop. Para. Therefore, this court is of the unhesitant opinion that the termination order dated 31/10/1999 cannot withstand the test of judicial scrutiny and is therefore set aside. Full stop. Para. The question now arises. The question now which now arises for determination is the action of provincialization of the services of the respondent number 8 by depriving the petitioner. Full stop. Admittedly, the respondent number 8 is junior in service to the petitioner and does not possess the requisite qualification of being a higher secondary pass. Full stop. The respondent number 8 also appears to be disqualified so far as age is concerned, as the prescribed age for entry into the service is between 18 to 36, and the petitioner and the respondent number 8 was 41 years while she had entered this age service. Full stop. Para. The Rajbol Bhuya, learned counsel for the respondent number 8, has tried to convince this court that the induction of the petitioner of the respondent number 8 should be taken from the year 1999, when a resolution was adopted to allow her to work. Full stop. However, on a close perusal of the said resolution, it appears that the resolution was only allowing the respondent number 8 to assist assist her husband, who was holding the post of LDA and was unwell. Full stop. This court is also unable to accept the proposition advanced on behalf of the respondent number 8 that she, being an existing staff, the qualifications laid down of higher secondary may not be essential. Full stop. This court is of the opinion that when the statute prescribes a minimum qualification, the same has to be followed. Otherwise, that might amount to be giving an endorsement to an act of illegality. Full stop. Para. The records which have been produced by M.S. Tarangpi, the learned training council of the department, is the record forwarded by the school authorities through the office of the inspector of schools, Kachar. The very act of filing an affidavit in opposition by the school authorities, by filing a common affidavit in opposition by the school authorities, along with the respondent number 8 in the first writ petition WPC 1651 2015 would prima facie demonstrate that the stand of the school authorities cannot be stated to be a neutral one, as apparently the school authorities have taken the side of the respondent number 8. Of course, the school authorities would have all the right to defend its action, but while doing so, it has the school authorities have merged their stand with that of the respondent number 8 by filing a common affidavit, which itself creates a great deal of suspicion on the neutral conduct of the school authorities. Full stop. Para juxtaposed, there is no doubt or disqualification or doubt regarding the qualification and eligibility of the petitioner for consideration of his service, for consideration of provincialization of his service. In that view of the matter, this court is of the view that the order of provincialization of the respondent number 8 is not backed by the sanction of law and is accordingly set aside. Consequently, it is directed that the case of the petitioner be considered afresh in accordance with the rules and the process be finalized expeditiously and preferably within a period of 2 months from today. Both the restrictions accordingly stand allowed. The records are handed over back to Mr. the learned department.
My lord, with respect to your lord's decision, my lord, regarding age, my lord.
No arguments of judgment. Yes, next.
Obliged, Judge.
Huh?
May I please, Lordship?
Yes.
Lordship, here the matter relates to Lordship, wrong recording of date of birth as per the respondent's Lordship in our service book. Lordship, what happened? The petitioner is an assistant teacher in the Vivekananda Vidyapith HS school.
Khatuni, you are there?
Yes.
Yes, Lordship.
Affidavit file.
Affidavit file, I have
Lordship.
the original record also.
And they have not denied it that they have accepted
Why to read petition?
Initially, Lordship, they have stopped my salary from August 2021. And
August 2021. Salary stop.
the salary stop, Lordship. And thereafter, they prevented me from discharging my duties. And
There is another cause of action.
Yes, Lordship.
Which is by which order?
Lordship. Is 50. That order has been set by this honorable court, Lordship, and they were directed to pay
The date of the order, discharging preventing or discharging duties.
on Lordship. This is on 5/9/21.
You are prevented.
Prevented from discharging the duty and also stop my salary.
The salaries were stopped from August 2021.
21
And
as
on
per
5/9/21, your order was passed not to preventing you from discharging duties.
no, Lordship, no order has been passed, but she was Lordship not allowed to discharge the duty from November 2021 as per their own affidavit.
Okay.
And this order was stayed by this honorable court, page 25.
Which order state?
Lordship, the stoppage of salary, Lordship. The
Stoppage
honorable-
of salaries was by an order.
by an order, Lordship.
Which order did it?
Order is the
5921, my lord. It is
5921.
intimation, my lord. Page 44, my lord.
Okay, what is the order of the court dated?
page 25, Lordship.
Date?
Date
This was in the first.
6/5/2020.
This was in the first petition.
Yes, Lordship. This is the
2929 in 2932.
Yes, Lordship. 11
65.
2022, my lord.
6522.
Court state 5921. Right?
Yes.
5921 was stayed.
Lordship.
In WBC 2932.
Yes,
Yes,
Lordship.
Okay.
But they have not complied it, not paid the salary or allowed her to join the
First, let us have a look at that order.
Page
See, 5921
24, Lordship.
is 24.
Page 24. Last paragraph.
24 of which writ petition?
5921.
You take up this consolidated writ petition, second one.
Lordship.
We have taken the second writ petition. Which one? 2184.
Yes, Lordship. Second one, Lordship, 2184.
Here, my lord, 44, page 44, my lord.
Page 44.
5921 communication at page 44, my lord.
44.
Yes, my lord.
44.
That's good. Yes, please. I am certain that your material will be held up until you produce the original corrected riches in respect of your date of birth. Okay.
Yes, sir.
This is which Vivekananda Vidyapith.
Lordship.
Vivekananda
Vidyapith. Higher secondary.
Vidyapith. HS. Where is it? Sonitpur.
Thekiazuli.
Casually.
Thekiazuli.
High school.
High school. Higher secondary. Lordship.
High secondary.
High school.
High
Yes,
school.
high school, my lord. HS, my lord. High school.
HS. Yeah, high school. Casually.
This is passed by the headmistress of the school.
Yes.
Lordship, on this order, communication has been stated, Lordship, page 24 of this honorable court's order, but they have not complied this order. No,
Let us see 24.
yes, sir. 11 is last paragraph, Lordship. Last paragraph. Yes.
Okay.
They were given the liberty to proceed with any inquiry if so advised, Lordship. But it is stated that they have no authority to hold up the salary of the petitioner. Administrator has no authority.
Okay, then.
Lordship, they have not complied this order. After that, we have filed a contempt petition. In the contempt petition, in this writ petition, Lordship, they have not filed any affidavit. In the contempt petition, they have annexed the copy of this impugn order, page 50, Lordship. This is the speaking order by the inspector of school,
50.
50. But personally, it is not served on the petitioner till date. Lordship, can you see the finding?
Yes. This is dated.
Dated, Lordship, 28/9/22.
Yes.
As per these findings, Lordship, the petitioner's date of birth as per her HSLC certificate is 6/10/1958, whereas in her service book, her date of birth has been recorded as 33/1966.
33.
33/1966.
Yes.
So it is ordered that as per their observation in the speaking order, Lordship, from the records and findings of hearing, it is found that the date of birth of Manju Gupta is 6/10/1958 as per her SSLC pass certificate and mark sheet issued by the Board of High School and Intermediate Education Uttar Pradesh. As such, her date of superannuation falls on 31/10/2018. Further, being a government employee, Srimati Manju Gupta has to know her date of superannuation, and she was supposed to intimate the authority about her retirement date on the basis of the date of birth as per school certificate issued by the board. It was her responsibility to inform them. Lordship. In view of the above, Srimati Manju Gupta.
Now, why this discrepancy kept in?
No, Lordship, actually what happened, Lordship, petitioner's original date of birth is 33/1966. Lordship, may kindly see the school leaving certificate, Lordship, issued by the Thekiajuli Government Aided High School. Page, Lordship, 26. She completed her primary education in Thekiajuli. She is a permanent resident of Thekiajuli, Lordship. It was issued on 10/10/1987. Lordship, 26.
Where is your matriculation certificate?
Matriculation certificate is at page 35, original one, and type copy is at page 34.
34?
Type copy.
No, let's see the original.
Yes. Original is 35.
Matriculation.
Matriculation. She completed her matric, Lordship, from UP. Lordship, after class 7, she moved to UP with her grandparents.
So here it's written 6th October 1958.
Yes, Lordship. This is Lordship 16 August 19. As per this certificate, her date of birth is 6th October 1958. And now the school certificate, Lordship, issued page 26. This is issued by the Thekiajuli Government Aided High School when she left the school.
Which school?
This is Thekiajuli Government Aided High School, Lordship. When she was promoted to class 7, Lordship, she left the school. And certificate was issued, Lordship, Mechanism 26. Certified that Manju Kumari Gupta, daughter of Vishwanath Prasad Gupta, an inhabitant of Thekiajuli in the district of Sonitpur, left the Thekiajuli Government Aided High School on 30/12/1978. Her age on that date, according to the admission register, was 12 years, 9 months. In 1978, 30/12/1978, Lordship, her age was 12 years, 9 months. And accordingly, her date of birth was 33/1966. As per this certificate, her date of birth is 33/1966.
But this will be sacrosanct, or the HSLC will be sacrosanct. This is by the school, that too in the year 1987.
Yes.
You left in 78. You left the school in 78. 87, you procure a certificate with a date of birth. And on the other hand, you appear in the HSLC from UP. Where admit card is given by the actual authorities.
Yes, sir.
Where your date of birth has been stated to be 6/10/1958. So if at all there is a mistake, you have to correct the date of birth in the HSLC certificate.
No, Lordship, she has applied after this order of communication was issued. Lordship, she have applied for correction, but they have said that within 3, if it is not corrected within 3
No,
years.
you knew that the date of birth was 6/10/58. How could the 66 be recorded in your service book? Tell us.
Lordship, what happened in class 9, she got married, Lordship. So thereafter, as a private candidate, she appeared in the HSLC examination.
From UP.
In UP. She moved to UP in class 7. Lordship, after that, due to some marital dispute, Lordship, she had to leave UP and move with her parents in Thekiajuli.
When did you enter your service?
Was in 1999.
From 99 till all
Lordship.
these years,
Lordship.
you knew that your medical, your HSLC had your date of birth as 6/10/58.
Lordship, at the time of my entry in the service, I have submitted an affidavit, Lordship. Affidavit is at page 36. This
Affidavit would be sacrosanct. See,
Lordship,
this certificate, HSLC certificate by UP was issued in August 1985. It was not a document which came to you much later.
Lordship, when she got admitted in the college, Lordship, this affidavit was shown, and this affidavit was also and accordingly in her college certificate, her date of birth has been recorded as 30/3/1966. And when she entered in service, Lordship, this affidavit was submitted to the authorities. And
By affidavit, you can change your date of birth.
Lordship, they have accepted it.
Who?
The authorities have accepted it and recorded.
Is that a correct procedure?
Lordship, date of birth has been recorded as 30/3/1966 and till 2021.
No, now a dispute has arisen.
Lordship.
Which document will they rely upon? Your affidavit or your HSLC?
Lordship,
And you have been said that
my
still
affidavit,
your case is open. You can still get a.
there is only one wrong entry in the HSLC certificate, but otherwise my date of birth as 30/3/1966 is corroborated by the other documents, Lordship.
What
Even
other document?
other documents, the school living certificate, Lordship, by the Thekiajuli.
That is a school living. That's a transfer certificate given in 87. You left the school in 78.
78, Lordship, but this certificate is issued from the records of the school, Lordship, from the admission register.
See, we have a school copy and we have a board's copy. Which will rely upon?
Even the progress report we have annexed, Lordship. Here also it is, Lordship, forward the claim of the petitioner that it is 66.
Progress report.
Yes, Lordship. Full
What
progress
progress
report
report?
is also annexed, Lordship. The original one.
Now, what prevented you from getting the date of birth corrected? If you say,
Lordship,
and what is, see the difference? Difference is 8 years.
8 years. Lordship, what happened?
Had it been 1 or 2 years,
after
your contact would have agreed that you have not bothered.
after passing of the HSLC examination, Lordship, she has to move to Thekiajuli, Lordship, because she has separated from her husband. And in this process, Lordship, she could not correct the date of birth because she was not. She never thought that she will further proceed with her study. But after she returned to her Lordship with her parents, then she again started her college, and then already 3 years have passed, Lordship. And Lordship, in the service book, it was recorded 33/1966, and it is not a case that any Lordship manipulation or anything has been done by the fabrication has been done by the petitioner. It was in their knowledge, and they have accepted it and recorded it in the service book and signed by the deputy inspector of school. And last 20 or 25 years, they have not disputed this fact, Lordship, that had date of birth in the HSLC certificate and in the service book, 2 different date of birth has been there. Now, Lordship, they have raised this question when she is only 3 years to go on retirement. As for 1966, she has another 3 years service. And also, Lordship, till the date of birth in the service book is altered, any alteration is made, Lordship, they cannot allow her to go on retirement from 2018 by taking 1958 as her date of birth. It is duly submitted, the HSLC certificate was duly submitted to them when she entered into service. They have not raised any objection or dispute or anything like that. They have accepted it.
Let us read the speaking order again now.
Yes, Lordship.
Finding.
There is nothing, Lordship. She simply said findings, Lordship. Page 50. They also rely only the SSLC certificate issued by the UP board.
It seems the inspector of schools have also taken the information from the Secondary Education Council UP.
Yes,
Then
Lord.
also, then only then after this order has been passed.
It is admitted fact that it is wrongly recorded in 19A. We have annexed it, the HSLC certificate. It is not that we have suppressed it, that our date of birth is something like that.
If you have not suppressed, then your retirement is at 18.
If 66 the original age, Lordship, it is another 3 years there. My service is there is
Now,
another
if
3 years.
if it is from
And
58,
58, then it is 2018.
18,
18.
what is the wrong? If you are not disputing this certificate, you have not
Certificate is
taken
wrong.
steps and for rectifying the date of birth. The authorities have also said that you can get your certificate rectified.
But if we would inform us that only 3 years period is there to correct any mistake, Lordship, already
This exercise was carried out in 21 for
21.
seniority, conferment of seniority. Then only it was detected.
Lord.
Can you
It-
find fault with the authorities?
It is not a Lordship case of newly detected, that suddenly detected that there is any wrong entry, Lordship. They have signed it in the service book. Lordship may kindly see the
But
service book.
if an error is detected, cannot it be rectified? After all, these are all public employment.
Yes.
Yes, Mr. President.
Lordship may kindly peruse
It
the
is
service
detected
record,
in the year
Lordship.
2020 because earlier she was working in a ME school. That ME school was amalgamated with the high school in the year 2018, madam. Hereafter, they have
One second. For this is for secondary.
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 Initially, she was working
She
in
was
IME
working
school.
as assistant teacher in Rashtrabhasha Vidyapit ME school.
Yes.
The said school was amalgamated with Vivekananda Vidyapit High School on 19/1/2018.
Okay. Yes.
Then, my lord, in the new school, we have prepared the seniority list.
Correct.
While preparing the seniority list, my lord,
You have detected this.
yes, my lord.
In 2021, Lordship. She transferred long back.
In fact, I have the original service book, my lord. In original service book, my lord, her date of birth was recorded as 33/1966 only.
It is signed by
But
the
while we are preparing the seniority list, we detected that actual date of birth is 58, my lord. That is why we issued the notice. And we have to consider the full living certificate, madam, or admit card. That is the only, until and unless she produced her birth certificate,
Corrected.
correct, or it is corrected from the authority, my lord. We cannot accept any other affidavit or something other, my lord.
It was submitted at the time of her entry.
We will come back to you, madam. Let him submit.
Look.
Have you seen?
I can produce the record, my lord. In fact, we have sent a letter to the secretary UP school. Secretary
That has
Education.
been reflected in the speaking order.
Yes, my lord. And we have got the information from them also, my lord. Here, my lord, they have
But
critically.
while okay, we accept that it was amalgamated. But while entering into the service in the ME school,
Yes, my lord.
you did not check up the
Normally,
HSLC.
it is required, my lord. We have to check the.
How was this wrong date of birth appearing in the Dhikajuli certificate that was taken into consideration and not the HSLC 58?
Then, my lord, maybe, my lord, on the basis of that school living certificate.
No, no,
Class.
that is the question we are trying to put to you.
Yes, madam.
That there is a certificate from the Jhekia Julie School from which our date of birth appears to be 30/3/1966. There is also an HSLC certificate given by the UP Council where date of birth is 58.
Yes, madam.
She has contended, and perhaps it's also an admitted fact, that in the service book 66 has been recorded
Yes.
instead of 58, and therefore her date of superannuation will automatically be after a few years.
Yes, madam.
So our question is that if both these certificates were existing and was communicated to you at the time of entry into the service,
Yes.
why 66 was recorded and why 58 was not recorded?
That is the wrong done by the department, madam.
Now, was this HSLC certificate furnished by the petitioner?
That I have to confirm with the earlier school, madam, because I have got the record from the amalgamated school. I have to confirm with the earlier school, earlier authority, madam, because that was done by the deputy inspector of school, day school. Now it is under the inspector of school.
Is she working now?
No, madam.
If you take a 66, when is to retire?
26.
26.
26.
And 58?
50 till 18.
As per my instruction, Lordship, HSLC certificate was submitted at the time of her entry in service. All the certificates were submitted.
Where have you stated?
Madam.
Lordship, page 11, para 9.
Yes.
That a petitioner completed her graduation in arts from LOKT College, Jhekia in the year 1998. Thereafter, pursuant to the recommendation of the Subdivisional Selection Board, Tezpur Business Subdivision, the petitioner was appointed as assistant teacher in Rashtrabhasha, Vidyapit, ME School, Jhekia by District Elementary Education Officer, Sonitpur, Tezpur, Vice Chancellor, dated 9/7/1999, wherein she joined on 10 July 1999. It is pertinent to mention herein that at the time of her appointment as assistant teacher, petitioner submitted the HSLC certificate issued by the Secondary Education Council UP along with the affidavit dated 23/10/1987, wherein her date of birth was correctly shown and the authorities duly accepted it without any reservation and objection and recorded her date of birth as 30/3/1966 in her service record.
What is the reply to this?
They have not replied it. They simply stated the fact
Let us see.
in their affidavit. There was comment not given, Lordship.
You have not replied to this.
No, they have not denied anything, Lordship, in the any statement in the petition. They simply said that as per the XSLC certificate, they have passed the speaking order.
Madam, this is not the way to file an affidavit. You have filed this. Affidavit is not narration of facts. You can narrate your facts in an independent paragraph. But you have to deal with the averments. That is the purpose of pleadings. What is the purpose of a written statement? It's only to counter the allegations made in the plaint. Same principle applies. This is not a counterclaim that you put your own fact. You put, but you have to meet the averment. There is no denial. This is not the way to draft an affidavit. And you have stated to the affidavit in opposition. Had it be some affidavit to bring into record some fact. There is no denial. And not only paragraph 9, he has not even seen paragraph 17. 17 is a very categorical assertion as page 17 of the writ petition. And it's para 17 which will be relevant because it's been verified to true total knowledge. 9 has been verified as record. There is no record to substantiate whether you have taken into consideration the affidavit. But 17 has been verified as true to the knowledge. Have you read 17, madam? Devi?
Lordship.
17.
Yes, Lordship. It is regarding our submission of all the documents. And on the basis of this, they relied on the date of birth as 33/1966.
Yes, how do you overcome?
Well, in any case, Malad, she was aware of the date of birth, Malad, regarding her
No,
matriculation.
see, if the case would have been different, here, she's in paragraph 9 and 17, she states that while entering into the service, the original date of birth, original HSL
Yes,
certificate containing the date of birth was submitted along with an affidavit. And you have accepted the affidavit and recorded the date of birth as 33/1966. If the amalgamation process was not done, then probably this could not have brought to
Detected.
light. Now, there is an anomaly which you have detected, maybe for whatever occasion. But can you now put her into a disadvantageous situation without rectifying the fact that at the time of entry into the services, you on your own, in spite of the date of birth being there, you have taken 33/1966.
Though she has made a statement in the petition, and in fact, we have not denied categorically in our.
There is no denial.
Yes, my lord. We have no denial. But from the service book, there is no reflection that she has submitted an affidavit showing her date of birth as she.
So what was the basis of 33/2066?
That is what I am submitting, my lord. That
From
is,
where did you get 33/66?
that is because of, my lord, she has submitted an affidavit. On the basis of affidavit, this date of birth 33.
Let us see the affidavit. Let us see the affidavit. Where is the affidavit?
Yes.
Madam,
Her affidavit, my lord.
come to page 36.
36, Lordship.
36. The affidavit, this has been reflected.
Yes, my lord.
It is not that she in affidavit she has said that I am born on so and so. She says that she has got a HSL certificate from UP which has recorded as 6/10/58 instead of so and so.
That is there, my lord.
It's not that she is tried to
Yes, yes.
they suppress anything. You could have rejected this affidavit. You could have said that no, we'll go by the certificate. And in the affidavit, since this paragraph 3 is government in paragraph 3 is there, we cannot accept your submission that the original certificate was not before us, so we could not know. Even if that was not there, you need the fact.
Yes.
And why haven't you abided by the court's order? Court did not ask you to pass a speaking order. 24, the order is 6/5/2022 of this court.
Yes, there was an observation in the court's order that, however, if the authorities are of the view that the petition is required to be proceeded against, liberty remains and tendency of the witness shall not be a bar for the same.
You proceed. You give her a show cause. This passing a speaking order is not.
Yes, my lord. While passing the speaking order, my lord, he was allowed to participate
No,
The
Lordship.
hearing was
No,
conducted.
it is
Where-
there,
where-
Lordship.
where-
Yes, my lord. I have the record, my lord.
Let us see.
Yes, my lord.
Let us see the speaking order again.
No suppose was issued nor any hearing has taken place, Lordship.
Hearing was taken place, my lord.
They
One
have,
second, one second, one second, one second.
They
Let-
said, Lordship. It is
Index.
denied by the petitioner.
He has signed the attendance sheet also, my lord.
Yes, you are there, madam.
Lordship, she went to meet the inspector of school for release of her salary. In that process, Lordship, she was asked some questions, Lordship, and they directed her to put signatures on the ground that anyone who visit the office needs to sign the Lordship register.
Where have you stated this?
Page 16, para 16, Lordship. May I read, Lordship? The petitioner begs to state that contrary to the claim of the inspector of school, Sonitpur district circle, Sonitpur, as made in the impugned order at the 28/9/2022.
We've read this, we've read, this is not
Page
enough.
relevant is page 17, Lord.
Okay, okay. 17 says also dealt with this.
The petitioner made
Catalonia-
the inspector of school to
We have read, madam.
Lord.
We have read it.
Okay.
But having her presence, there is no written statement by her.
Yes.
You have got the written statement from the headmaster of the high school.
Yes, my lord.
You could have more elaborate procedure is required. Give her a chance.
Lordship, there is also order of the Honorable Apex Court that at the second of the career, Lordship, the date of birth cannot be altered, which is also it is applicable to the employee and also applicable to the employer, Lordship. Eighteen and 21 last 3-4 lines.
Yes, have you read this? 18 and 21.
Yes, my
21 last part. Not it. The same analogy will also apply to an employer.
employer.
And here it appears that since the affidavit also discloses about the HSLC certificate,
That is
that you cannot now take up the plea that it was never brought to your or there were any suppression of material facts. You could have very well said that no, this is not enough. We'll go by until you bring us a corrective certificate. And there is no denial from
in our affidavit.
what if we said in your affidavit.
The only stand is that, my lord, during verification, the, during preparation of the seniority list, we could found that her actual date of birth is 1958 as per her.
But that was already there.
Because my lord, here the situation is because in the new school they are not aware of that, my lord. While preparing the list,
New skill is maybe under a different directorate.
Yes.
Yeah, earlier school is also under a directorate.
yes, ma'am, that is there. That is there. The HSLC certificate was there, or the affidavit was there, my lord. But-
Affidavit has to be there, otherwise you don't get 66 also.
Exactly, my lord.
To gather from somewhere 66,
Yes, my lord.
affidavit is the only
Yes, my lord.
paper and it has got reference to 58.
Yes, my lord. But it was detected while preparing the seniority list, my lord, in the new inspector of school.
It is their negligence, Lordship, if they cannot detect it till 25 years of her service. And even
Because
after
Otherwise,
her informing
initially
it,
there was no occasion to go through it, my lord. While preparing the seniority list, we got the occasion and then we detect, my lord. I think-
Anything else?
Otherwise, I have the record, my lord. Record reflects that notice was given to her, my lord, and she appeared before the inspector of school. She put her signature in the attendance sheet also.
as per my instruction, Lordship, no notice has been received. And also when the date of birth has been recorded as 33/1966 without any alteration in the date of birth, also they cannot stop her salary or prevent her from discharging the duty. Otherwise, also she is a cancer patient, Lordship. She is under treatment in cancer hospital. So for last 3 years, Lordship, she is suffering without any salary.
The judgment.
Yes, my lord.
MSRDB, Learned Council for the petitioner. Also heard Sri NJ Khatuniya, Learned Pending Council, Secondary Education
Secondary.
Department. Full stop. Para. Considering the subject matter This is a 23 matter.
23, Lordship. Earlier one was 22. This is a continuation of the earlier petition.
Considering the subject matters involved in these two petitions filed by the same petitioner, comma, the same are taken up for disposal together at the admission stage. Full stop. The petitioner is an assistant teacher in the Vivekananda Vidyapith High School, Kekiajuli, in the district of Sonitpur. Full stop. The petitioner was initially appointed in the, what is the name of the ME school?
Rashtrabhasha.
Rashtrabhasha.
Okay.
Rashtrabhasha.
Rashtrabhasha ME School.
Rashtrabhasha Vidyapith ME School.
Rashtrabhasha Vidyapith ME School, comma, in the year 19, in the on 19/1/2018, comma, the said ME School was amalgamated with the high school above him, and thereafter the petitioner had been working in the amalgamated school as an assistant teacher. What is लिखा है hereinafter school Vivekananda. While in service, comma, a communication was issued by the headmistress, public secretary of the school, dated 5/9/2021, withholding the monthly salary of the petition from August 2021. Full stop. Such withholding was on the ground that there was variation in the date of birth of the petitioner, which would appear from the HSLC certificate. Full stop. The aforesaid communication, the aforesaid communication was the subject matter of challenge in the first writ petition WPC 2932 of 2022, and this court had passed the following order, passed an order on 6/5/2022, the relevant part of which is extracted herein below. पूरा relevant part of which is extracted herein below. This court by an order dated while issuing by an order dated into that character. This court क्या लिखा? मैं उसके ऊपर लाइन पूरा passed an order dated 6/5/2022, issuing notice of motion, and had also made certain observations which are expected herein below. यहाँ से हाँ, page 24A से इस तक. इस तक. the though the impugned communication dated 5/9/2021 was paid, comma, these salaries were not released as a result of which, leading to filing of a contempt case by the petition. Full stop. In the said contempt proceedings, comma, a speaking order dated 28/9/2022 was produced in order dated passed by the inspector of schools, comma, Sonitpur district circle was produced, whereupon the contempt petition was withdrawn,
Lordship, close, Lordship,
closed,
since they are passed the order.
closed, and thereafter the second writ petition WPC 2184/2023 has been instituted, challenging the said speaking order dated 28/9/2022. Full stop. There are MSDB, the learned counsel for the petitioner, has submitted that it is a fact that our matriculation certificate issued by the, is it a council or board?
Lordship, both.
By the board of the state of UP, record her date of birth
Sir, sorry, sir.
as 6/8/1958, which was due to inadvertence.
It is a council, my lord.
Council, I think.
Lordship, sorry, sir.
Council,
My term
board
is
ne
six,
hai,
sir, sorry, sir.
council. Now even speaking order says it's a council.
Council.
Due to inadvertence. Huh? To substantiate such claim, comma, the learned council has referred to a school living certificate issued by the Dekiazuli Government Aided High School when the petitioner had left the said school while she was reading in class 6, and as per the said certificate, comma, her date of birth on deduction would be 30/3/1966. Full stop. It is the case of the petitioner that she had left the state of Assam and was in the state of UP, from where she had passed her HSLC examination, and in the admit card issued by the UP Council, comma, as stated above, comma, her date of birth was incorrectly written as 6/10/1958. Full stop. Sir, the pleaded case of the petitioner is that it is ठीक now. Due to certain matrimonial disparity, comma, the petitioner had come back to her origin, to the state of Assam, and was duly selected for appointment in the Rashtrabhasa Vidyapith ME School as an assistant teacher. Ms. Devi, the learned counsel, by referring to the affidavit submitted at the time of entry into her services submits that the said affidavit had clearly mentioned about the wrong entry, about the wrong recording of the date of birth by the UP Council as 6/10/1958 instead of 33/1966. It also appears that the certificate of the UP Council was also submitted at the time of her entry into the service. MS Devi further submits that accepting the said claim fortified by the certificate issued by the Dhikiazuri Government Aided High School, her date of birth, the service book was recorded as 33/1966. Full stop. Para. MS Devi, the learned counsel submits that after the ME school was amalgamated by order dated 19/1/2018, a fresh seniority list was prepared, and while doing so, the issue which was almost settled at the time of entering into the services was once again raised. Full stop. It is the contention of the petitioner that the authorities which were aware of the entire facts and circumstances, having acted upon and proceeding with the date of birth of the petitioner as 33/1966, no adverse action could have been taken by taking recourse to the erroneous entry in the HSLC certificate of the petitioner issued by the UP Council, which was within the knowledge of the authorities at the time of entry into the service. Full stop. The learned counsel further submits that the restriction, the embargo upon an employee to make an endeavor to change the date of birth at the fag end of service is equally applicable to an employer, and in this regard, he has relied upon the case of Shankar Lal versus so passed by the Honorable Supreme Court in Civil Appeal number so on 24/2022. On the other hand, Sri N.J. Khatuni attending council, Secondary Education Department, submits that the impugned order dated, impugned speaking order dated 28/9/2022 does not absolutely has not absolutely brought the matter to a culmination, and the petitioner is still given a chance to have the date of birth recorded in the certificate by the UP Council rectified, which after which the views of the authorities would be modified. Also, he further submits that it was only after the amalgamation process, when the seniority had to be recasted, the matter could be detected, and there was no occasion earlier to go through the age certificate. The Learned Council has also, Learned Standing Council has also submitted that an affidavit in opposition has been filed on 12/6/2020, whereby the action of the petitioner, of the respondent, has been defended. Referring to the speaking order dated 28/9/2022, the Learned Standing Council submits that the same was passed after giving adequate opportunity to the petitioner, and the order itself reflects that the petitioner was given a scope of hearing. He accordingly submits that there is no error in the decision-making process which may not warrant interference by this court in exercise of powers under Article 226 of the Constitution. Rejoining her submission, MS Devi, the Learned Counsel for the petitioner, contends that though an affidavit in opposition was filed on 12/6/2023 by the department, there is no categorical denial of the averment made in the writ petition, and there is no denial paragraph wise either. With regard to the submission made that the original certificate issued by the UP Council concerning the date of birth was submitted at the time of entry into the service, the averment made in paragraph 17. What was the other paragraph?
9, my lord.
9 and 17 have been pressed into service. The same reads as follows. 9 or 7. Reference to the averment. No, not the Learned Council further submit that no opportunity was granted before passing of the speaking order dated 28/9/2022, and with regard to the observation that the petitioner was heard, the learned counsel has referred to the averment made in paragraph
16.
16, wherein it has been stated that though the petitioner had met the inspector of school, that was with regard to the matter of release of her salary, and her visit has been manipulated in the speaking order by stating that the petitioner was heard. Full stop. The relevant averment of paragraph 16 is expected herein below. Page 7. What are those corrected? It will 16 class for it. Full stop. And counsel for the petitioner reiterated that none of the aforesaid categorical averments have been denied by the respondents. The learned counsel has lastly submitted that the petitioner is suffering from serious ailment, and therefore depriving her from her salary at this juncture is not at all justified. And in this regard, she has referred to the the averments made in paragraph. I think you have made somewhere about the arrangement. You have read somewhere.
Yes, 41 is the certificate.
No, your ailment.
Ailment. Yes, Lord.
You have made a
Certificate is-
no, you have made a statement.
But-
We have read somewhere. Yes, in paragraph 11, refer to the government made in
Yes.
paragraph 11. The relevant part of which is expected herein below. Page 12, paragraph 11, B2B. The learned counsel has also referred to the medical certificate annexed in this regard. To compare. The rival contentions made by the learned counsel for the parties have been duly considered, and the materials placed before this court have been carefully examined. To compare. Generally, the extraordinary powers of this court conferred by Article 226 of the Constitution of India, this court is loath in interfering with matters pertaining to change of date of birth at the fag end of the career, which is normally seen to be mooted by the employees with the intention to get some extension. Full stop. However, each case would depend on the facts and circumstances. Full stop. Para. In the instant case, there is admittedly variation in the date of birth. Full stop. While the council of the state of UP has issued the HSLC certificate stating the date of birth of the petitioner to be 6/10/1958, the school of Decade where the petitioner had studied up to class 6 record record her date of birth, which is deduced as 33/1966. Full stop. The matter would have been totally different if the HSLC certificate of the UP Council was not brought to the notice of the authority at the time of entry into the service. Rather, to the contrary, the state, not only the state certificate was produced, the affidavit, an affidavit was also submitted stating that the said recording of date of birth was incorrect and the correct date of birth was 33/1966. The aforesaid position appears to have been accepted by the authorities at the time of entry into the service of the petitioner in the Rashtrabhasa Vidyapit ME School, which was under the Directorate of Elementary Education. Full stop. At no point of time, the issue was ever raised, and therefore it can be presumed that the position was accepted that the date of birth of the petitioner was 33/1966. However, since there was an amalgamation of the state school with the high school, and the question and the issue of recasting of seniority had come up, the question of date of birth of the petitioner had again cropped up, leading to the present action impugned in these two writ petitions. Full stop. This court is of the opinion that since admittedly there was no misrepresentation or suppression by the petitioner while entering into the service, as would be evident from the affidavit filed, affidavit dated 23/10/1987, submitted along with the certificate of the UP board at the time of entry into her service, the issue regarding her date of birth had attained finality, which cannot be reopened now. Full stop. This court has also seen that the averments of the averments made in the two writ have not been denied, and and the writ petition also contains a certificate from the Dhekiyajuli government aided high school, from which it can be deduced that the date of birth of the petitioner is 33/1966, and this position was accepted by the authorities, as elaborately stated above. With regard to the legality of the impugned speaking order dated 28/9/2022, though there is an observation that the petitioner was heard before passing of the same, the explanation given by the petitioner in paragraph 16 of the writ petition, as quoted above, have not been controverted. Full stop. Even assuming that a hearing was afforded to the petitioner, that perhaps would not be sufficient, as the impugned action having adverse civil consequences would have to be preceded by giving an adequate opportunity to the petitioner to place her case, which cannot be said to be sufficient by simply giving her a hearing at the time of passing of the order. No, the record does not reveal that any inquiry was conducted, giving the petitioner any opportunity to present her case before passing the impugned speaking order. This court has also this court also finds force in the argument made on behalf of the petitioner by relying upon the case of Shankar Lal, in which the Honorable Supreme Court has laid down as follows. Paragraph 18 or 18 or 20. The relevant portion of which is expected here in view of the aforesaid facts and circumstances and the principle of law explained by the Honorable Supreme Court in the case of Shankar Lal Supra, this court is of the view that a case of interference is made out, and accordingly, the speaking order dated 28/9/2022 is set aside. Consequently, the petitioner is directed to be allowed to discharge her duties till her date of superannuation by reckoning her date of birth as 33/1966. Full stop. It is further made clear that the salaries for the period which has been held up be released immediately. More particular, immediately, which is the requirement of which is more in view of the serious ailment of the petition. Full stop. It is also made clear that there should not that the authorities should not consider should consider the petitioner to be in continuous service for the period from which she has been debarred from discharging her duties. Petition accordingly stands allowed. Yes.
Area salary since August 21.
All,
Obliged.
both the petitions specified. Yes.
Hello, good morning.
I'm sorry, Lordship. I was confessing.
What was the matter?
My lord, it is a
Insert.
in seniority, my lord, conflict, my lord, this petitioner is the original employee, original teacher of this school, and he's the amalgamated school teacher, the ME school teachers. Now, the petitioner is given in charge headmaster, charge of in that was reversed, and claiming that he is senior. But their ground is that the graduate scale was found by him earlier in 2013. The petitioner got the graduate from provincial resident, but otherwise all criteria was met. 10 years of graduate scale, then B.Ed, BSc, everything is there. Now this crisis matter is that whether the senior
Islam for response number 4.
yes,
What do you say?
My lord, to clarify the seniority dispute, Lord,
Today we may not have time for disposal.
yes, ma'am.
may not have.
It's a top of the list at
One additional affidavit thought
from 20 it is pending, and this top of the list also today. My lord,
I will have it on Tuesday.
my lord, then top of the list.
Tuesday for disposal.
Yes, my lord.
Mr. Islam, you have filed your affidavit.
Everything is accepted.
BDC additional affidavit has already been filed.
Filed. You are supporting Mr. Islam.
Lordship, actually responsible for how a senior I have made.
According to his senior.
Yes, Lordship. He has not completed qualified service for
10 years he has not
10 years
completed.
completed, my lord. How he can say 1/1/2013
to
1/1/2013 2023 completed.
23 now, but order was in December 2020.
December.
December 2020. Only
December
7
20 or 10 years was not there. 7 years.
1/1/2013, my lord. 1/1/2013.
10 years will be when?
My lord,
The petition was instituted itself in 21. It could not, even at the time of institution, it was not 10 years.
my lord. Another point is, my lord, if this petitioner is not
You have to
entitled,
be very careful when Mr. Islam is there.
yes. My lord,
Lordship.
if this,
What,
You
my
have
lord,
to,
my lord,
what he wants to argue, I can argue and decide. Your lordship can decide in 2 minutes with a decision of the Honorable Supreme
well,
Court.
take 2 minutes. We'll take
Why?
We'll take
What
1
he
minute.
is arguing that
1
he-
minute only.
Lordship, what he is arguing his entire earlier period, page 102, Sabbath devotion, is to be counted for seniority. And my seniority has been, I was appointed in 1992, June. Service was regularized in 94, confirmation in 2005. And he disputes my transfer. That transfer
No,
again,
no, before we come to your case, he has to first stand up on his own leg.
that is correct.
Whether he has completed 10 years.
Yes,
If
not.
somebody who is not eligible is before the court, we may not like to
No.
enter into a dispute. First,
Lordship.
you have to establish your case.
my
Mr.
lord,
Varun.
secondly, my lord, another aspect, my lord. The criteria for headmaster is explained in Rule 14. Rule 14 says if ME school amalgamated to the high school, the headmaster of the ME school becomes the assistant
Assistant
headmaster.
headmaster, correct?
So the senior most incumbent, he becomes assistant headmaster, still he is holding. And he is the junior most teacher of the ME school, and not the original teacher. He is come from other school, 2015. So 2015, if he forego his seniority on his own
But
request,
what right do you have to raise this question?
My lord,
Even if we interfere with his promotion or appointment,
yes.
will you get any benefit?
Yes, my lord, because there is a instruction from this honorable court also that you make up a regular procedure for in charge, the senior
But
most.
you have not completed 10 years as on the date when the decision was taken. You will not be getting any benefit.
My lord, this is a in charge headmaster. In charge, my lord, this senior most was given, but regular they have not initiated the regular.
See, there are
procedure.
decisions of this court, even for in charge basis, temporary basis, the
That-
qualifications are necessary.
Yes.
Jagannath, I think that
Yes.
is, or Jagannath Pegu, I think. Justice Amitabh Arora.
Now,
Jagannath.
my here submission is his seniority is only 4 years in the school, amalgamated school, including ME school, and in high school.
Okay, Tuesday.
Rule, Lordship, kindly on 22nd, Tuesday I have problem, on 22nd.
What happened to your gym case?
Oh, Zim case, now they have compromised. Both the sides, complainer and the respondent.
Daughter-in-law running a gym.
What to do? My
Compromise.
lord, in this
Okay.
case, my learned senior friend is arguing a simple thing. Before provincializing seniority in Bhansar period, that he wants to count. Page 107 of the compilation, my lord, 1985 to SCC, that judgment will do. When rule is there, rule will prevail. If rule is not there, then this officiating earlier service, that will count. Now, Rule 24(3) of 2018 rule is very clear. Transfer within the same district. So, from 1996 to that 2015 transfer, authority says it is after obtaining NOC within the same district. That part I will retain. Subsequently, this Tangapara ME
Okay,
school and high school got amalgamated.
Tell us the date. Date.
22nd.
22nd.
As a my lord, fixed item.
Oh, first item.
Today it was first item.
Yes, I was there. Madam must have.
Next day, don't remain elsewhere. We will take it up even if you are not there. And who is, where is Mr. Das, SK Das?
Status is with me.
Though this matter was called up as first item, and accommodation was sought for. However, later, paucity of time did not permit the matter to be taken up. Considering the purpose of listing of this matter as top of the list, list again on 22nd of list top of the list, as agreed to by the parties, list again on 22nd of June. Mr. Borwa, have a look at this citation. I'd like to have your views also. Item? Yes, madam. What is this?
That relates to selection and appointment of the petitioner as the library for the post of the librarian in the madrasa school. She applied.
Functioning. Madrasa school is functioning.
Respondents were directed.
Madrasa are functioning.
Not functioning as madrasa, but as a normal high school.
Instruction. What is the present position?
Then I have to
Get the instruction. There is change of circumstances. You should get the instruction. 16 matters.
Lordship, then give us
16 matter.
on.
Next Friday.
Okay, Lordship.
Next Friday. You have to take instruction. Yes, you are for whom?
I am for respondent number 5.
Respond number 5.
Yes.
This item number. Third, MS Nanda. A Nanda.
Lordship,
U Nanda.
on behalf of exhibitor.
Heard MS U Nanda, learned counsel for the petition. Also heard Sri Khatuniya, learned standing counsel, secondary education department, whereas Sri A Hussain has appeared for the respondent number 5. Full stop para. The matter pertains to selection and appointment to the post of librarian in a madrasa school. Full stop. This court has been informed that there is some development. There is some development whereby the madrasa schools were converted to high school. High school. Full stop. Para. The learned counsel for the parties are accordingly directed to obtain instructions from the respective clients. Full stop. Considering that this petition is of the year 2016, comma, list for admission on Friday next.
Okay.
Next Friday, 23rd. 23rd.
Obliged.
11.
Here, petitioner is accommodated in the year 2020, accommodated as a teacher, a tutor method.
R. Burwa. Nobody is there. None appears for the petitioner on call. On the other hand, Sri P.K. Bora,
Two petitioners.
learned counsel for the
Elementary
Education Department, submit that the petitioners have been accommodated as tutors in the meantime, and therefore there may not be any existing cause of action. Full stop para. Be that as it may, common and in the interest of justice, matter change adjourned to be listed again on Wednesday next. Full stop. It is, however, made clear that in case of further default on behalf of the petitioner, comma, this court would pass appropriate order.
Here also, my lord, I was offered accommodation, but he has not.
Madam, what is this?
Is regarding not getting the salary of teacher. Salary is not receiving since the month of August 2007.
This is a contempt matter or what?
Well, one contempt is also pending, filed by the petitioner.
And this one, madam, what is this?
This is the repetition.
Single petitioner.
Yes, Lord.
Yes, what about this appointed as tutor?
Here, my lord, petitioner has offered accommodation, but he has not joined.
He has not joined.
Not joined.
You want to pursue with this?
I may got the instructions.
You obtain the instructions.
Yes, Lord.
You may still choose to pursue this, but depends on your client. Are you aware that she has been offered the tutor job?
No, Lord, we are not aware of.
From where are you making the submission? You got instructions.
My lord, I have.
Some written instructions you have.
My lord, I have a communication.
Can you grant place a copy of this?
My lord, I'll forward it.
Not to the court also.
My lord,
And we can grant ask a copy to be given to her.
my lord. Just now I'm talking.
reinstated petition has been filed for a direction for release of arrear salaries from the month of August 2007 as well as current salaries to the petitioner who has been working as an assistant teacher.
Yes.
Which school? Jidal
Jidal Patrichuk LP School in Dhemaji.
Patrichuk.
Yes, Lord.
Jadal
Jidal Patrichuk
Patrichuk
LP School.
LP School in the district of Dhemaji. MS Sri P. Bora, Learned Standing Council, Elementary Education Department, submit that as per instructions received by him, comma, the petitioner has, comma, in the meantime, offered the appointment of tutor after a policy decision in case of teachers, in case of persons who were appointed as teachers illegally. MS Diangana,
Yes.
Learned Counsel for the petitioner, however, submits that she is not equipped with any instructions from her client. Sarah, that this matter will be listed when?
Lordship on
Next Friday?
Yes.
Is it possible?
Lordship,
Are you in touch with the client?
I may take some time, Lordship. On 26th,
Monday, okay. Release this case on 26/6/2023 to enable the learned counsel for the petitioner to take instruction. Can you give a copy?
My lord, I have.
A copy of the instruction pertaining to the appointment of the petitioner as tutor may be furnished to MS Angana, the learned counsel for the petitioner, to enable her to obtain instruction. Sarah, a copy of the same may also be is also placed with the case record.
please.
Apply.
May please, Lordship. This is the matter related to non-payment of salary. It's related to Srixagar district, Your Lordship.
This is item number
13, Your Lordship.
okay.
Pursuant to the advertisement dated 28/12/96, Lordship, they were
Again, same kind of
My
matter.
lord, here also.
I don't
Tutor.
know instruction.
Here also accommodated.
Tutor.
But we plan, Lordship, we prayed for payment of our salary.
No. You take instructions whether you are satisfied with tutor or you want to pursue this.
Yes, I'll take
Take
instruction.
instructions.
Can it be
We'll have it on
after the
26.
Bihu holidays,
26.
after the summer vacation?
Bihu holidays will be
No,
good.
no.
We can
Summer
construe. We can construe as Kati Bihu. That is the nearest. 26. No. After summer holidays.
Yes.
Okay, on 19th.
Right.
Same order. Yeah, come to Madam.
Let a copy be provided to
Yes.
me, my
You have a copy?
Yes, I'll provide.
B. Bhuya, senior counsel. Which school?
Lordship, different schools of Srixagar district, Your Lordship.
Or petitioners? There are more than 1 to 10, 11
Yes,
petitioners
the
about
11
different schools in the district of Srixagar. So all of them have been accommodated.
My lord.
Are we to be Bora accommodated? Rural Purdue as tutor.
Apply.
My lord, I'll provide the copy.
We'll have it on when?
19,
19th of July.
apply.
Apply.
Others may not be possible to take. Anything, yes, yes.
My lord, item number 29. I have some urgency, my lord. Next week.
What is the urgency?
Urgency, my lord. We are not given time scale of pay regularization.
There is no urgency.
My lord. Yeah. Earlier order is there, my lord.
You ask your client to give some peace to you and also to the court. What is it?
Next week, my lord.
If it comes on its own, I will come. I will not fix it. Item number?
Item number 29,
Case of which year?
19.
19. Okay, we'll have it on next Friday.
Later on Thursday, my lord. Friday may not reach.
Okay, possibly. Any case where interim order is still today?